Good morning, everybody. We're here today for the very first day of our 23-24 term. I understand it's the 132nd year that this court has been hearing cases as the Seventh Circuit. Before that, it was something else. So, counsel, you have the honor of presenting the first case of the year. We're going to begin with appeal numbers 23-1528 and 23-1530, United States versus Pacilio and Bases, and we're going to begin with Mr. Loeb.
May it please the court, Robert Loeb for appellant John Pacilio. I'm sharing time with Mr. Allen, who's representing Mr. Basis, and we'll be dividing the time for the opening 10 minutes and 6 minutes and trying to save 4 minutes for rebuttal. I'm going to address the due process fair notice argument and the fraud conviction. Mr. Allen's going to be addressing the prejudicial trial error of allowing improper lay testimony. In its brief on appeal, the government concedes that the due process fair notice issue is a matter of first impression for this court, and that contrary to the position that it took in the district court, that it is not controlled by Kosha or Chanu and must be decided here for the first time on appeal. Given that admission, with your court's permission, I'm going to start with the due process fair notice argument. This court has held that the due process fair notice issue is one of law and has explained that it is an objective test. This court explained in Harris that the inquiry is whether, at the time of the conduct at issue, the application of the law to a particular circumstance was objectively ambiguous. This court says if it is objectively ambiguous, then the law fails to provide the fair notice that is required. Now, this court and the Supreme Court have said that that standard is very similar to the qualified immunity, clearly established law standard that applies when you sue government officials. You look as to whether a reasonable officer would have known that his conduct was unconstitutional. And here we have to look at whether a reasonable, objective trader would have known the conduct here was criminal fraud. And here at the time—
Mr. Loeb, does your argument here apply to both wire fraud and the commodities fraud statute?
It does, Your Honor.
How do you get around that the Supreme Court, our circuit, has long recognized that omitting material information or providing half-truths have long been considered fraud?
Right, this court has always looked at this as to the application to the particular circumstance. So the question is, was it clearly established at the time that the conduct here of trading, whether you frame it as the government does, as trading with an intent to cancel, or as the indictment does, of trading, making the statement—
But you agree that it's long been recognized that omitting material information for your own benefit is a theory of fraud.
But certainly it is a theory of fraud. And the question is, would a reasonable trader believe that trading with an intent to cancel, as the government frames it, was depriving the market of material information? Would it be considered fraud? And at the time of the actions here, if you look at all the material that was before an objective, reasonable trader, it was an objectively reasonable position to believe it was not fraud. Let me just tick through a few things a person would have known at the time. At the time, the district court and the Fifth Circuit sitting in Bank and Radley said that even if a trade is placed with no intent to actually enter into a transaction, that's in the Fifth Circuit opinion, it is not fraud if the bids were in fact at risk of being executed. And the district court, which was affirmed by the Bank court, explained since the defendants were willing and able to follow through on all bids, they were not misleading. So it was not a material misstatement. So it was not to be considered fraud. So a reasonably objective trader, knowing the Radley decisions—
How far does Radley get you? Because in Radley, the defendants there actually bought the product, whereas here they didn't.
Here, there were some trades which were executed and some were not, just as in Radley.
The theory of the fraud here is that there were trades placed that were put out, there were buys put out that they fully intended to execute, and then they put out these what I'll call spoofing orders on the other side that they did not intend to execute, that instead those were intended to manipulate the market in the direction to make the first one more profitable. That's what the theory has been. And in Radley, it was different because the traded issue was actually executed or the product was impacting the market was actually purchased. Where here, that's not what the theory was.
There were multiple bids made in Mr. Radley, and if you look at the Fifth Circuit opinion, it says those were placed without the intent to execute those trades. But let me, I think your point is one that they're making a false appearance to the market about these trades. The standard that even the CME said in its letters after Dodd-Frank was enacted, and this is really important, at pages 61 and 70 of the appendix, you have these letters from the CME to the CFTC, and they're trying to explain what is a spoofing order that should be prohibited, because the CFTC has asked the parties, the players to alter for their views on that. And they said in their letters, this is the CME talking, that if a bid or offer can be executed before withdrawn, it is a live offer, and it does not create a false appearance of market depth. That's in both those letters from May and January of 2011, because they are actionable until they're withdrawn. So the CME is telling you there is no fraudulent misstatement. No doubt the CME didn't want this practice because they said it was a disruptive practice. It wasn't good behavior. But they said it was not sending a false appearance of market depth. That's a quote from the letters to the market. And that's the whole theory of the government here. So the question is, could a reasonable trader, seeing these letters from the CME saying this is not a fraudulent statement, knowing that the CME standard defining what an offer and a bid turns on willingness to have the trade executed, and that if it does, you will fulfill your obligations.
Under that theory, though, Mr. Loeb, there would be no convictions under Chanu.
Well, this is a temporal analysis. We're not arguing, Chanu was years after the fact here. So certainly a reasonable trader after the Chanu decision isn't engaged in this behavior because Chanu said, oh, that's fraudulent.
But even if we take the facts of Chanu and we overlay it on that theory, there would be no conviction, right?
They didn't make this due process argument there, as the government it admits.
I understand they didn't make it. I'm just saying if we take your theory to the logical consequence, it wouldn't have resulted in a conviction in cases which have been affirmed.
That is most likely. The facts of these cases are a little bit different. But yes, that is, and the indictment there is different. Here, there's the indictment about wanting versus willing. But yes,
well,
I think
that's not. There's one paragraph in this indictment that talks about willing, but essentially the other allegations in this indictment are essentially the same as Chanu and Cassia.
Yes, and I'd like to get to that, but I think just focusing on the fair notice argument, you have to look at both everything the trader knew. So you have the Radley decision saying that if it's an active trade that can be traded.
Can you address, when you're addressing what the trader knew pre-Dodd-Frank, all of the guidance about manipulating the market? So there were CME rules and regulations about market manipulation. True, it didn't use the word spoofing. True, it didn't talk about the specific things that Pacilio and Bases did. But there was guidance about taking actions to manipulate the market.
There were general statements and CME rules about market manipulation. This is not a market manipulation case. There are separate statutes addressing it. There are separate rules regarding it. This is a criminal fraud case where the whole case is premised on that you are making a false statement to the market.
In order to manipulate it.
In order to manipulate it, the false statement it all turns on that you are representing to the market of the false order. And that we have at the time of the action here, we have the CME before and during this action are writing letters to the CFTC saying, no, these are not fraudulent orders, they're not misrepresentations to the market of market depth. You have the Fifth Circuit and Bank sitting and saying, no, it is not fraud, it's not sending false, these are not false trades. These are real trades that are subject to being executed. Many of the trades here were executed. And even as late as 2004, post-Dodd-Frank, 2014, post-Dodd-Frank, we have the CFTC in its filing to a federal court in the Wilson case saying that spoofing is a disruptive practice, it's prohibited, but it does not sound in fraud. That's the language of the CFTC. So certainly a reasonable trader back in 2009, 2000 could share the same view that the CFTC expresses in 2014, that this conduct of trading with an intent to cancel, although it's a live trade, does not sound in fraud. A reasonably objective person could hold the same view as the CME, as the CFTC, and certainly as the Fifth Circuit and Radley. You can't imprison somebody today based on when they're holding the same views as is being expressed by the regulator and by the Fifth Circuit and bank. And I think it's also, so all these positive things would have told the trader that this is not fraudulent conduct, but you also have to look at the dog that's not barking here. If it had been...
Isn't that directly contrary to what we found in Cassia? Because in Cassia, I mean, you're quoting from Dodd-Frank, we held that Dodd-Frank provided fair notice and afforded due process, despite that argument. So it sounds like
that was a
you're saying
different due process argument about the terms of the Dodd-Frank statute.
But the same terms that you're relying on
No,
it was a direct challenge to the Dodd-Frank statute, but you're now trying to use this information about Dodd-Frank and these communications about Dodd-Frank to bolster your other argument. And we rejected those in Cassia.
Respectfully, Your Honor, that was about the different language and construction of what the elements were of that disruptive practice. And here, Mr. Pacilio was found not guilty of those charges, and that's a different charge. The question, is it fraud or not?
Did you want to reserve the rest of your time for rebuttal?
Thank you, Your Honor.
All right, thank you. We'll next move to Mr. Allen.
May it please the court, David Allen on behalf of Appellant Edward Basis. The district court erred below when it admitted lay opinion testimony from representatives of the CME and bank compliance officers to offer the opinion that rules and policies, which on their face said nothing about the conduct at issue, prohibited broad practices like fraud, manipulation, and so forth. He admitted opinion testimony that those policies and rules were understood at the time to prohibit the defendant's trading. And that testimony should never have been admitted because there was no basis to connect those interpretations to either the appellant's state of mind at the time or to market participants generally and what they understood to be conveyed by orders on the CME. As you know, there were two critical questions at trial: whether orders on the CME carried the charged implied representation, whether there was a sufficient market understanding to give rise to that implied representation, and two, whether the appellants knew prior to Dodd-Frank, prior to the CME's rule on the issue, whether they knew that real tradable orders conveyed false information to the market simply because they didn't want them to be executed. And the challenge testimony was critical to the government's attempt to answer both those questions. The government's now attempting to simply, frankly, walk away from the case that was actually presented to the jury, but it really can't do so. The government stated itself pre-trial below, when we challenged the CME witness testimony, that the CME representative's interpretation of Rule 432 would quote unquote eviscerate the defendant's defense that their orders did not convey the charged implied representation. That on opposition to our Rule 29 motion, they again said that that testimony allowed the jury to conclude that that charged implied representation was carried by the CME orders. And again, on closing, and this is worth hearing in full, the government argued this conduct is, quote, obviously wrong and was never allowed because Mr. Snigowski, that's the CME representative, explained that spoofing is prohibited and always has been by the CME rule against engaging in fraud and acting in bad faith. That's Rule 432, end quote. Now, after making all those arguments and those statements below, the government tries to argue here that Rule 432 was not really the quote-unquote predicate for the defendant's convictions. But that's simply not true. The government argues that instead the predicate was the false statements. But the basis for the government's theory below that these orders, if there was anything false about these orders, was entirely based on Rule 432, its interpretation that was offered. And
Mr. Allen, why wouldn't the jury instruction given by the court address your argument? Were the court specifically instructed then that just a violation of these rules alone is not sufficient to convict them of any of the charges here, that this is really an intent issue?
So I think there's two separate issues. So there's the question of intent, and the jury instruction did instruct that a simple rule violation is alone not to sufficient to establish fraudulent intent. But Rule 432 was used
No, it
for
was more than that. It wasn't sufficient to prove that they had committed the fraud. So beyond just intent.
Correct. So I agree that instruction was given, but the entire premise of the supposed false statement here was the market understanding that was based on Rule 432. So yes, the government didn't argue.
Was it the market understanding or the defendant's individual understanding based upon training that they had received?
So two separate issues there. So one, does the implied representation exist? And that is a question that turned on, well, what did market participants writ large understand to be represented by these orders? And that was fundamentally based on Rule 432. If you look at the testimony of the alleged victim representatives, they based their understanding on the quote-unquote rules and so forth. And then the government tried to close that loop by putting forward the CME witness to explain, well, this is the rule, and this is what we thought it meant, and therefore you can find this implied representation. Then there's the second issue of the defendant's fraudulent intent, which Rule 432 again factored into, despite the lack of evidence that anybody was aware that the CME interpreted Rule 432 to prohibit this conduct. And that also goes to the compliance officer testimony. As Your Honor mentioned, the compliance policies prohibiting manipulation were presented to the jury. On their face said nothing about spoofing, nothing about intent to trade, bona fide orders. But the government was allowed to put on representatives from these banks who weren't in positions at the time to know what was communicated to traders. Admittedly, they testified. They could not testify to what was communicated to the appellants. But they were nonetheless allowed to testify that this prohibition on manipulation was understood by, quote unquote, the banks to prohibit this conduct. And on that basis, the government argued throughout trial, they conflated these, frankly, distinct concepts between manipulation and fraud.
And then, of course, these witnesses were subject to cross-examination. So I have not been through the whole trial record, but I can imagine there's a number of blows landed by attorneys on behalf of your client, Mr. Loeb's client, that would point out this distinction, correct? And then the jury receives that distinction and they make their determination with regard to their verdict.
Yeah, absolutely true. The compliance officers were crossed. It was brought out that one of them didn't even work at the bank at the relevant period, and so forth. I agree. But I don't think it should be left to the defense to try to counter this evidence when it should not have been admitted in the first place. What you had was you're presenting two purported authorities, compliance officers at two of the biggest banks in the world, to come in and basically choose up sides. They say, yeah, we support the government's theory here. But there was no evidentiary basis for the jury to infer that the appellants shared that understanding.
Did you want to reserve the rest of your time for rebuttal?
Yes, thank you.
Very good. Thank you, Mr. Allen. We're now going to move to counsel for the appellee, Mr. Lehrman.
May it please the court, Dan Lehrman for the United States. I'd like to start very briefly with 1 minute on sufficiency and then move on to the notice argument, because I think sufficiency is kind of the threshold argument here. The notice argument follows on to that somewhat. It is undisputed that the defendants placed orders on the opposite side of the commodities market with the intent to cancel, and that is the exact conduct held to be fraudulent in Chinoo. And on appeal, the defendants do not dispute that they in fact engaged in the same conduct. So their only response on sufficiency is that the indictment alleged that they did not want the trades to execute. Judge St. Eve, as you noted, the indictment did in fact allege numerous times in numerous places that they placed the orders with the intent to cancel. It repeatedly called that the false statement, the misleading statement, the fraudulent statement. So that claim is without merit as a factual matter. I also wanted to make the point that the cases they cite for that proposition, Sterone, Leichtem, and Adams, those are all constructive amendment cases. And so the language they cite from that are cases that go to the question whether, by virtue of the evidence at trial and instructions to the jury, the indictment was constructively amended at trial. For sufficiency, it's black letter law that the only question is whether there was evidence such that any reasonable juror can find guilt beyond a reasonable doubt.
But while you're on the indictment,
Excuse me?
I said while you're on the indictment, the appellants do take this one paragraph, actually wanted to trade the fraudulent orders when in fact they did not want to do so. So there is that one paragraph in this multi-page indictment. Why did the government replace this language between the second and third superseding indictment? Why did it go from willing to trade to actually wanted to trade?
I don't know why they went from willing to want. I will say I do think it's true that they also did not want these trades to occur. I think in many ways want and intent have very similar meanings. I think if you intend, if you say that you want to kill someone and then push him into the L tracks, a jury can infer that you intended to kill the person. So I don't think there's a ton of daylight between them, and I think we're kind of dancing on the head of the pin here. The main point is that that's not the only paragraph that uses the term misrepresentation. The fraud statute talks about false statements or representations. The overarching purpose of the conspiracy was to send materially false and misleading information that indicated increased supply and demand. That's paragraph 4. Then you have all the other paragraphs that we quoted in our brief that talk about how the definition of the fraudulent order was placing orders that they intended to cancel to convey a false signal of supply and demand. In their briefing below at both the motion to dismiss stage and the Rule 29 stage, they invoked that very same definition of fraudulent orders, and the argument was that as a matter of law, it is not fraudulent to place orders with the intent to cancel. They didn't make this want versus intent argument until after Cheney, because Cheney squarely forecloses this argument, as Judge Brennan mentioned. But turning to the fair notice challenge, this is an as-applied challenge. It is still relevant, and we don't concede that we changed our mind in any respect, that this court held in Cheney that spoofing is a quintessential misrepresentation within the meaning of the fraud statutes. And Judge St. Eve, that is the question for purposes of fair notice. This is a as-applied challenge. So the question is, you look to the facts of this offense, and the facts here are placing orders with the intent to cancel in order to send a false signal of supply and demand. Any reasonable trader would know that that is fraud, and the jury in fact found that they placed these orders with a specific intent to mislead. They therefore knew that it was misleading to do this. Their overarching argument is once again that they were not on notice that it was fraudulent to place orders that you didn't want to cancel, but that's just a rehash of their sufficiency argument in two ways. One is, as I just explained, the offense conduct here is placing orders with the intent to cancel, so whether they also knew that you couldn't place them wanting to cancel is beside the point.
What's your specific response to what Mr. Loeb has said about what a reasonable trader knew in 2009, so pre-Dodd-Frank, and then also based on the CME guidance, the letters from the CFTC about what sounds in fraud, what doesn't? What's your specific response to those items?
My specific response is that changes the actual my threshold response, and then I'll turn to your question, is that changes the threshold inquiry here. The indictment alleged and the jury found that they placed orders with the intent to cancel in order to send a misleading signal. That is fraud, and it has been fraud for 150 years. So the question is not yet whether or not they had specific evidence that a particular rule said something was against the rules. They were not convicted of violating CME Rule 432. They were convicted of violating the fraud statute. So the only question is whether, taking the facts of this case, a reasonable person would be on notice that it fell within the words of the statute as interpreted by case law. This court has long interpreted the case law to apply to implied misrepresentations, omissions, and half-truths, and that is the conduct at issue here. But if you look to the rules themselves and the bank policies, the rules themselves prohibit engaging in any conduct to manipulate the prices of exchange futures or options contracts or to upset the equilibrium of the market, creating a condition in which prices do not reflect fair market values. The Deutsche Bank and Bank of America policies prohibit placing orders to give a false impression of supply and demand. That is all exactly the conduct for which they were convicted here, and that is exactly the conduct for which they were convicted in Cheney. If we talk about the CME letter, which again was not really evidence presented below in this context, all that said was that there needs to be some intent to mislead. Well, that was with respect to the CFTC, the statute, the Dodd-Frank, but for purpose of fraud, we know there was intent to mislead because that's a requirement under the statute. So there's no inconsistency there. Another one of the letters from the CFTC even made clear that these new anti-spoofing rules were always unlawful under the statute. The cases are legion that the same conduct could be criminal under multiple statutes. Kosha held that it was criminal under both the fraud and the spoofing statute. This court's decision in Dial made clear that things like insider trading and pump and dump schemes are wire fraud before there were specific rules and regulations outlawing those schemes. But I would like to
The defendant's point on Kosha, though, is that we didn't specifically address the due process argument. It wasn't raised. I know it was raised below, but it wasn't raised on appeal.
That is correct, and that is the big concession we made, that Kosha did not address that particular
Nor did
thing.
Cheney.
Or Cheney. But It has always been the case that these types of misrepresentations are fraud. A dial made clear that even placing an order for the purpose of conveying a false signal of the bona fides of a trade could be fraud. So I think they had, even at a lower level of granularity, noticed that the conduct here was fraudulent. And to answer your question, there's not really any dispute. I believe they conceded that order placement signals an intent to trade. That's what all the rules went to, that there's a background assumption that they knew and that market participants knew that order placements were expected to be bona fide. There's no dispute that they placed these orders here with the intent to cancel, that is, orders that were not bona fide. So it is.
I don't know if they agree with that at all. In fact, they make a point of teaching us that most orders end up being canceled. But you can understand some confusion or at least dismay here that if it was illegal all along, as the government contends, why don't we see any action on this until after Dodd-Frank? The first prosecutions were kosher, and then we have Chanu and Worley, and all this happens after Dodd-Frank specifically defines spoofing. Where were the prosecutions long before this if it's been fraudulent from day one?
Well, I believe the district court decisions address that particular argument, and what they made clear is that this is a new type of fraudulent conduct made possible by the advent of high-frequency and algorithmic trading. The chats here show their fraudulent intent and show that they knew they were misleading the market. When they talked about, quote, manipulating the market and, quote, effing the market and, quote, tricking the algos, what they're talking about is manipulating them into seeing a false signal of supply and demand.
That didn't start until 2007, correct? The algorithm trading?
Yeah, it was
On the
late
platform.
in the history.
It was late in 2007,
Yes,
I
so
think.
it's true the fraud statutes have been around for 150 years. This particular conduct has not. But the cases make clear that for the notice question, Your Honor, the question is whether you're invoking a novel construction of the statute or applying it to novel conduct. Even if they're right that this is novel conduct to which it has not been applied, that doesn't mean you're invoking a novel construction of the contract. The first person to do the Nigerian print scheme via email could still be prosecuted for fraud, even if he was the first one to use email to do it.
Is this distinction that we're discussing, does that account for the not guilty verdict for Mr. Bases on the spoofing count? Count 20, I think it was?
I can't speak obviously exactly to what he was acquitted for on that count. It could be that. It could be that I believe he made an argument below that those were trades from different accounts. So it's possible that the jury found that they lacked intent, the fraudulent intent with respect to that one particular charge. But here there were multiple other alleged cases of spoofing for which there was abundant attempt. So again, just on the notice, there is no reasonable dispute that the conduct here, which is placing misleading statements to the market, is fraudulent. It's not a tautology to say that. It's not a tautology just because something is correct. That has been the inquiry for as-applied vagueness challenges, and they don't point to any case in which the fraud statutes have been struck down for similar reasons. If I could turn now to the evidentiary issues. With respect to both the testimony from the CME officials and the big testimony, I would again just point to the fact that there's little dispute that order placement signals an intent to trade. And that is largely the purpose for which these rules and regulations were introduced. I could read them again, but I think they make clear that orders should be placed as real orders and not orders that you intend to cancel. And that is the background assumption. But in any event, as Judge St. Eve made clear, the jury was instructed that this alone is not evidence of fraud, and they were not convicted for violating the rules. This was just regular custom and practice testimony. They can see that such testimony is generally admissible, and the testimony is plainly relevant. So their main critique is that there was no evidence from which a jury can infer that the defendants knew this. But as Judge Brennan said, they were cross-examined on what the market knew, what defendants knew, what they told defendants. So this is really a question of weight and not admissibility. But in any event, the district court did not abuse its discretion in concluding that the jury could make that inference. These were experienced commodities traders. The evidence showed that other traders had the exact same understanding of the rules. Petty and Twells, the victims, and Lacan all testified that the CME rules prohibited the placement of orders with the intent to cancel. That shows that this wasn't some secret rule. This is regular custom and practice testimony, and it's testimony that they don't really dispute, because although they obviously dispute whether it referred to or alleged anything about spoofing in particular, this is a fraud case, and that just means you can't make a misrepresentation. And it was clear that the market would assume, and they knew, that this was a misrepresentation. Again, there was abundant other evidence of their intent to defraud, including the chat messages, where they expressly talked about manipulating and tricking the markets. Other witnesses had the same testimony. For the reasons I said, the rules themselves, both the bank rules and the market rules, talk about manipulating the market, talk about sending a false signal of supply and demand, talk about changing the information about demand and pricing and moving markets. So this is all squarely within the scope of the conduct in any event. If there are no further questions, Your Honor, the government would ask to affirm.
Thank you, Mr. Lehrman. Mr. Loeb, I'm going to increase your rebuttal time to 4 minutes, and you may approach.
So counsel kept referring to the fact there was false signals being made to the market, and that was well established that when you do that, you're committing fraud. But what he's not addressing is the fact that even after Dodd-Frank, the CME is saying that when you're trading with an intent to cancel, if the trades are live, they are not creating a false appearance of market depth. So there is no false signal, even according to the CME. They're saying this is not a practice that we endorse, but they are saying, if you look at pages 61 and page 70 of the appendix, that it is not a false signal. The false signal theory is just incorrect.
How does that square with what we held in both Chanu and Cassia, that spoofing is illegal even if the trades that they did not intend to execute are readily tradable?
Again, the due process argument is a temporal one. So a trader post-Koshin, post-Chanu, those would be problematic. The question is, would a trader at the time who saw these CME letters saying there is no creation of a false appearance of market depth by these trades where you intend to cancel, if they knew the Radley decisions, that a reasonable person could have believed at the time, objectively believed, that this was not fraudulent conduct? I mean, the fact that this court in Chanu took a different position doesn't mean that it was clearly established at the time. And Your Honor's question about the lack of enforcement or conviction is very telling here. If in fact this was always fraud and this was always prohibited conduct under the rules, you would have had some dog that barked here that explained it in between, even if it was only 2007 to 2011. But we have no trader that's disciplined, no trader that is warned, no trader that is sanctioned. We have no case, we have no administrative decision of people who are engaging in this conduct. And this conduct was prevalent. That's why the CFTC asked for it to be considered a disruptive practice and be prohibited by conduct. So it was out there in the marketplace, but no one is warned, no one is sanctioned, no one is disciplined. Moreover, the training materials they tried to bring in, they couldn't find any training materials from the period of time that says this is fraudulent conduct or this is prohibited conduct. And it's very telling that post Dodd-Frank, now you do have training materials. Once it is prohibited, you're telling the traders don't do this. Beforehand, as the CFTC says itself, and even post-Dodd-Frank, no one considered this to be actions that were sounded in fraud. Post-KOSA, post-Chanu, that's a different world. But the question is, can you imprison someone when they're trading at the time when the Fifth Circuit, the CFTC, and the CME is saying that you are not sending these false signals to the marketplace? My clients, we were sentenced to a year and a day in prison for doing things that were not objectively considered illegal at the time, and they should not be in prison, Your Honor. And so as to the witness point, this is not. You keep going back to the facts and sufficiency. The fair notice argument is an objective, legal argument, and but to the extent you're going to look at, they rely on these CME officials. That flies in the face of Farinella, where this court said you can't bring in officials years after the fact to tell the court and to tell the jury, how the law should have been construed or how the rules should have been construed. And this
But
is how
wasn't Farinella different? Because in Farinella, the witness's interpretation of the FDA rules is what was the basis for criminal liability. Here, the basis of criminal liability is not a violation of the CME rule. It's a violation of the fraud statutes.
That is correct, but the basis of the fraud is the misrepresentation. The misrepresentation here is based on the act of placing a bid or an offer. And those bids and offers are defined by the CME rules. And those CME rules tell the marketplace what those mean. And so they brought in these witnesses that, yes, these rules are telling the marketplace and that they were going to trade, they wanted to trade, and that they weren't going to cancel. Of course, we know from the record and from the amicus brief, 90% of all trades are canceled, so that's a ridiculous proposition. But they brought in these witnesses, as my co-counsel said, to be devastating witnesses to say under the material misrepresentation is founded upon Rule 432, which the district court itself said as a matter of law is ambiguous.
Thank you, Mr. Loeb. Thank you. We're now going to move to Mr. Allen for your rebuttal.
First of all, the government said that the admissibility, the testimony of the CME witnesses and compliance officers is a question of admissibility, a question of weight rather than admissibility. That's not the case. Without any basis to infer that the defendants knew these interpretations that were being offered, it was simply irrelevant and it was extremely prejudicial to their defense. It's essentially conceded that there was no basis to infer that the defendants were aware of it. All they can point to, the government can point to, is that the appellants were employed at the banks at the time. That simply is not a fair basis to infer that they understood a post hoc interpretation offered by somebody who wasn't at the bank at the time, a decade after the fact, was something that they were aware of. The government also points to the testimony of the victim representatives and the government cooperator as an independently sufficient basis to sort of corroborate that the defendants understood this and that everybody in the market understood that there was this implied representation. That's not the case. If you look at what the victim representatives actually testified to, they were all over the map. They all testified that the basis of their understanding of what orders represented was the rules. When asked what those rules required, they couldn't point to Rule 432, but they said bona fide, intent to trade. It was extremely contested below. What does that mean? Does it mean willingness? Because there really was no basis for the jury to conclude that the defendants weren't willing to trade. And the government's now saying, well, this worked in Chenoo. There was similar testimony about bona fide intent to cancel. But Chenoo is not this case. That's not how they proceeded below. And whether the court holds the government to the specific representation alleged in the indictment wanting to trade or not, that's how the trial below proceeded. They argued to the jury repeatedly. They elicited testimony from the CME that Rule 432 required wanting to trade. The victim testimony didn't support that fact. The cooperator didn't support that interpretation. All they said was intent to trade. It was very much at issue whether intent to trade meant willingness or something else, as Mr. Loeb has articulated.
Thank you very much. Thank you, Mr. Loeb. Thank you, Mr. Allen. Thank you, Mr. Lehrman. The case will be taken under advisement. We're now going to move to appeal number 21-1970, Cosenza versus Kijakazi. We're going to begin with oral argument from the appellant, and I'll recognize Ms. Meeks.
Good morning, Your Honors. Catherine Meeks for appellant Jamie Cosenza and her son J.F. The ALJ in this case incorrectly denied disability benefits to J.F., a young adult who suffers from severe and lifelong learning disabilities. This court should grant J.F.'s unopposed motion to join this case as a party because his participation fully resolves any question of whether this court has subject matter jurisdiction. On the merits, the court should remand for a new hearing because the ALJ repeated the same analytical errors that compelled the court to vacate the ALJ's disability determination in Hopgood versus Astru.
If he becomes a party, if we grant the motion, given that he's an adult, you agree we use his full name rather than his initials at this point?
That's correct, Your Honor, yes.
And are you still arguing that Ms. Cosenza has standing on her own?
We do. Because she initiated this case as a representative of her son, we think that the court doesn't need to inquire into her own standing and can look through to her son's standing, and that's sufficient. But under the facts of this case, we think she has her own Article 3 standing. And
Have
that's
you
because
found any cases, sorry to interrupt, Ms. Meeks, but have you found any cases where a court has held that a parent of an adult child has Article 3 standing in this capacity? You cite a bunch of cases about representative payees, but they don't discuss the standing in particular.
Sure. The cases that address the parents representing the children, they recognized that the parents had standing.
Correct.
This factual scenario
It's
arises
unique.
so infrequently, yes, that we don't have a case on point, but we cited the Access Living versus Uber case, which recognizes a similar theory that diversion of a party's resources can be sufficient for Article 3 standing. And here, the fact that JF lives in the same household as Ms. Cosenza, there's no dispute that she provides for all of his basic needs, and we think it's very likely she would serve as a representative payee under the regulations if he were found to be disabled. Both of the psychologists who examined JF in connection with the disability application concluded that he would require a payee, and the regulations say that a payee should be a relative who has the claimant's best interests at heart. And because she lives in the same household as JF, she could commingle any benefits with her own funds. And this set of facts we think is sufficient to give her her own Article 3 standing. But because the motion to add JF to this case is unopposed, we think that's a simple means of disposing of any question about whether the court has jurisdiction here.
So your argument is clearly far and above a no harm, no foul argument. You're saying there's actual aspects of an Article 3 standing.
Yes, we think that Ms. Cosenza has her own standing, but the court doesn't need to inquire into that question because we've asked to join JF as long as one party has standing to seek relief, and the only relief we're seeking here is vacature and a remand for a new hearing. As long as one party has standing, that's sufficient, and the court doesn't need to separately inquire into whether any other party has standing here. So turning back to the merits, I'd like to address the acquiring and using information domain. If the ALJ had found a marked rather than a moderate impairment in this domain, that would have been sufficient for a finding of disability. As in Hopgood, the ALJ concluded that JF had a less than marked impairment because she blamed his struggles in school on his behavior and attendance issues, which she characterized as personal choices. But the ALJ ignored the overwhelming evidence in the record that these behavior issues were actually symptoms of his disability rather than a volitional choice. So I'd like to walk the court through a few examples of evidence that the ALJ completely overlooked. So at Appendix 42, a school occupational therapist found that JF's attention and behavior in the classroom were caused by his difficulty with sensory modulation. At Appendix 64, a 2010 school report concluded that his significant behavior problems resulted from an emotional disability. At Appendix 66, and again at Appendix 241, two different individual education plans, or IEPs, attributed JF's significant behavior issues to his educationally based diagnosis of Asperger's syndrome. And then finally, at Appendix 251, a 2016 teacher report concluded that his lack of organization in the classroom was intrinsic. So even under a deferential substantial evidence standard, the ALJ can't ignore highly pertinent evidence that's favorable to the claimant, and that's exactly what happened in this case. We think the ALJ made a second error straight out of Hopgood when she relied on modest improvements that JF made on individual assignments to conclude that he had a less than marked impairment in acquiring and using information. But she failed to explain how, if at all, she accounted for the fact that JF achieved these improvements only with substantial accommodations, including longer amounts of time to take tests, frequent breaks, the use of a scribe to help with written test answers. The ALJ was supposed to compare JF to peers who did not require accommodations, but she overlooked evidence that his performance in school was, to use the words from a school report, significantly discrepant from that of his peers. So, for example, the ALJ completely overlooked evidence at Appendix 227 that standardized tests in 2016, which was his last year of high school, placed him in the bottom first percentile nationally for reading and the bottom second percentile for math. At Appendix 47, a 2010 school report reported nearly the exact same results. The test placed him in the bottom fifth percentile nationally for reading and the bottom first percentile for math. At Appendix 62, other standardized tests from 2010 placed JF in the extremely low and borderline categories for reading and math, which were two standard deviations below the national mean. And under the regulations, 2 standard deviations below the mean is evidence of a marked impairment. That's at 20 CFR 416-926A. So under a straightforward application of Hopgood, we think that this evidence that the ALJ overlooked justifies remand and a new hearing.
Let me ask you this. Do you think if Ms. Cosenza had updated the record with records from his adult years, that would have helped her case in any way? And, what should we think about that as we evaluate the ALJ's disability determinations on the adult side? Because she's drawing all these conclusions from the child records.
The child record. So there was a consultative examination when he was an adult by Dr. Lana, who concluded that he had extreme difficulties in interacting and relating with others. If the case were remanded for a new hearing, I think Ms. Cosenza and JF would welcome the opportunity to supplement the record, but the ALJ didn't reject the disability claim on the ground that the evidence in the record was insufficient, and Ms. Cosenza made a representation at the hearing that any new evidence would likely be cumulative of what was already in the record. The ALJ had asked if a school counselor, if she would be permitted to send a questionnaire to a school counselor, and Ms. Cosenza's view was that the school counselor had already signed the IEPs that were in the record, so it would likely be cumulative. But as I said, I think she would welcome the opportunity to submit additional doctor reports if the opportunity were given. So beyond the errors I discussed,
Ms. Meeks, why aren't, as you know, the standard of review here is substantial evidence, and the ALJ's opinion was pretty detailed, and on the question of acquiring and using information, she relied on teacher evaluations, she relied on the IEP documents themselves, recognizing that he certainly had challenging issues, but noting that his behavior regularly impacted his academic career. She relied on his own statements from the hearing, which you're asking us to discredit, but we can't reweigh testimony. She relied on the state psychologist opinion. She noted his standardized scores had improved. So unlike in other cases, there's a lot of information that she relied on here, acknowledging some of the deficiencies, but ultimately reached her conclusion. It sounds like you're asking us to reweigh that.
Sure. So the ALJ's opinion is quite long. It's 78 pages, but it's very repetitive. She sort of summarizes this evidence and then kind of cuts and pastes it and repeatedly discusses it in the context of different domains.
She relies on the same evidence for different things, but I'm focusing on really the two challenges that you have had made here, and her discussion is pretty detailed.
Sure.
And relies on very specific evidence on the acquiring and using information.
Sure. So her actual analysis is quite perfunctory. It's limited to just a single paragraph for that factor. That's at the short appendix 30 and the short appendix 47. And although the ALJ, discussed the teacher reports, we think that she completely overlooked this evidence that I discussed a few moments ago that was favorable to JF, and in her actual analysis, she relied on teacher reports that said, for example, he had behavior issues and attendance issues that affected his performance, but she didn't explain why she credited that evidence instead of other evidence in the record that was not discussed that attributed those issues to his disability. So the ALJ, she's not required simply to acknowledge that the evidence exists. She's supposed to build a logical bridge between the evidence and the record and her conclusions. And here the ALJ, in her one paragraph, just kind of with her ultimate decision on the evidence, didn't explain why she rejected certain evidence and credited other evidence. And Judge St. Eve, you asked about the claimant's testimony when he was 12 years old at the hearing. He said he could be a straight A student but was just fooling around. In other parts of her opinion, the ALJ didn't credit the claimant's testimony. She said she thinks the record doesn't support the extreme limitations alleged by the claimant or his mother. So she made essentially an adverse credibility determination and yet accepted this sort of damaging testimony from a 12-year-old boy who was given leading questions by the ALJ, who asked him several times, isn't this your fault? And he sort of capitulated and said yes.
Did you want to reserve the rest of your time for rebuttal?
Yes, thank you, Your Honor.
Very good. Thank you, Ms. Meeks. We'll now move to argument from the appellee, Ms. Payne.
Good morning, Your Honors. May it please the Court. Lindsay Payne on behalf of the Acting Commissioner of Social Security. With respect to the jurisdictional issues in the case, if the Court does grant the motion to bring JF into the case, that would resolve the Article 3 standing issue raised by the Commissioner. And
you don't object to that motion, correct?
We do not object to him being a part of this case.
Being a party to the case.
Correct. And so the only question before the Court on that issue is whether Mr. Freed should be joined or should be substituted. As set forth in the briefing, the Commissioner questions whether it's appropriate for Ms. Cosenza to remain in the case, but will defer to the Court's judgment on that issue.
And you agree that you've waived your objection based on the real party and interest as to Ms. Cosenza?
We certainly agree that that is an issue that the Commissioner should have raised in the District Court. This Court has made some statements in the past about prudential standing being sort of in between as far as whether it's completely waivable. Appellant has agreed that it is still within this Court's power at any time to add or drop a party. But as far as the Commissioner's position goes, yes, we should have raised that earlier, and so we will just defer to the Court. As long as he is brought into the case, there is nothing that would stand in the way of this Court's jurisdiction. Turning to the merits of the case and childhood disability in particular, the key to the childhood disability issues in the case lie in the 6 domains that comprise the functional equivalence analysis for childhood disability. And what appellant's argument here is really missing and failing to acknowledge is the separation between those different domains. A child satisfies the criteria for disability if he has marked limitations in 2 domains or extreme limitations in 1 domain. This is not a nebulous inquiry wherein all of the child's symptoms and behaviors are lumped together in one pot. The domains are clearly broken down and they require separate findings under the regulatory scheme. So here, the ALJ found that as a child, JF had marked limitations in just 1 domain, that was attending and completing tasks, and she found less than marked limitations in all of the other domains. Appellant has only challenged 2 findings by the ALJ. Those would be the findings of less than marked limitations in acquiring and using information, and less than marked limitations in interacting and relating with others. So the question always has to return to whether substantial evidence supported the ALJ's findings on those two particular points with respect to those two domains. In her lengthy discussion, the ALJ amply supported those findings. Even here today, in appellant's argument before the court, it's unclear how the behavioral problems appellant is referencing relate to the domain of acquiring and using information that's being argued about. So counsel referenced sensory modulation, lots of behavior problems. The ALJ accounted for those in her finding that JF had marked limitations in attending and completing tasks, and also that he had some limitations, but less than markedly so, in acquiring and using information and in socially interacting. The support provided for the ALJ's findings and the breakdown between the domains is really where the distinction from the Hopgood case comes in here. In Hopgood, the ALJ disregarded certain behaviors that the child had because the ALJ found that they were volitional choices. Here, the ALJ considered them and attributed them to the various domains. In doing so, she relied on specific record evidence, primarily from JF's teachers, to determine that while he had marked limitations in attending and completing tasks, he had less than marked limitations in the other domains. I am unable on the fly to compare all of the specific record citations given by counsel in argument here to the ALJ's 78-page decision. Some of them do, though, seem to be information that the ALJ did discuss. The ALJ did discuss for example, the standardized testing and how JF was able to improve his scores from year to year, showing that he was acquiring and using information.
Well, let me ask you about one specific example that's related to improvement, but this is grades, and it comes directly out of Hopgood, where the ALJ talked about the claimant's improving grades over time, but our court held failed to account for the fact that the claimant was in special education courses and that teachers were having to accommodate him, and these accommodations were happening at the same time. Can you talk about that in this particular case? The interplay between special education, which JF is in, the courses, and his claim of disability, because I don't see that in the ALJ's decision. I don't see where the ALJ, who talks about the fact that his grades improved in 12th grade, he's got all these other failing grades from all these other years. And so sure, they may have improved in 12th grade, but he also is in these special education courses where teachers are accommodating him, where he doesn't have to produce 100% of the work, just like the claimant in Hopgood, okay? And where less is expected of him in those courses. So can you talk about how the ALJ handled that?
Absolutely. I think the ALJ's decision demonstrates that she was well aware of the IEP documents. She talked about how JF was in special education, and where this case differs from Hopgood is the wealth of information that the ALJ had here about what JF's own teachers were saying about his functioning in the classroom and what the reason was for his problems. Certainly any sort of problem relating to any of the domains that a child could have could impact their grades. So for example, a child with significant health problems who's unable to attend school regularly due to a physical condition could have a significant impact on their grades. So the ALJ here really had to get to the bottom of which domains were affected for JF. She had very specific information from his teachers. As the ALJ discussed, for example, the 6th grade teacher, Ms. Williamson, stated that when JF was motivated, he showed very little problems acquiring and using information, and that he was capable of learning new material and applying problem-solving skills when it suited him. His 7th grade teacher, Ms. Moss, generally indicated only slight problems in acquiring and using information. His 8th grade teacher, Mr. Cooper, pointed to a lack of effort and focus as the cause of JF's academic difficulties. JF consistently tested in the range of low average to average intelligence. While he was sometimes, and this goes again to your question, Your Honor, while he was sometimes noted in school records to be working 1 to 2 grade levels behind in his curriculum, he was also at times noted to be working at grade level. So this is looking specifically at what is he able to achieve as far as math and reading in comparison to his peers who are not in special education courses. And he was able to either be at grade level or be 1 to 2 grade levels behind in what he's achieving, which is a separate question from the grades that he earns, which in part rely upon him actually turning in assignments. While he showed problems completing his homework and attending school, he also showed that he could earn passing grades on his homework and that his grades improved as his attendance improved. It wasn't unreasonable on these facts, with the record before her, for the ALJ to find moderate rather than marked limitations in acquiring and using information, but that JF had more significant problems with attending and completing tasks. I'd also point out, counsel in her argument referenced the ALJ not considering an alleged diagnosis of autism in this case. There is no diagnosis of autism in this case that was extensively litigated. We have record evidence of Ms. Cosenza telling Mr. Freed's pediatrician that he had autism caused by vaccines, despite there being no autism diagnosis in the record. His pediatrician stated that she found no evidence of autism, that Mr. Freed had normal psychiatric and behavioral findings. And so,
what is an educationally based diagnosis of Asperger's? What's the work that educational is doing in that phrase?
my understanding from the record is simply that Ms. Cosenza told the support personnel at the school that JF had autism, and they accepted that. There's no comprehensive evaluation by any sort of professional of JF that would substantiate a diagnosis of autism, and there's not been any argument that the ALJ erred in her finding that he had only 2 medically determinable impairments, which were a vitamin deficiency and an unspecified learning disorder. This also ties into the Hopgood analysis and also appellant's argument in the reply brief, which cites to the regulations and to various district court cases, arguing that the ALJ here impermissibly failed to consider that JF's impairments could impact multiple domains, that any one given impairment might impact multiple domains. But the ALJ's decision here proves otherwise. They cite to 20 CFR section 416.926A, which states any given impairment may have effects in more than one domain. In a Social Security case, impairment is a term of art. Mr. Freed was only found to have those 2 medically determinable impairments. Notwithstanding that fact, the ALJ found, based on those 2 impairments, that JF had limitations in every single one of the 6 childhood domains, showing that the ALJ understood that impairments can and do affect multiple domains. It was Mr. Freed's burden, since he moved to join, I started using his name in my head with JF. It was JF's burden to show how the evidence actually compelled a finding of marked as opposed to moderate limitations in these other 2 domains, and he failed to do so. As the court has referenced, it's inappropriate at this stage of the litigation for the evidence to be reweighed when it was already fairly considered by the ALJ. That goes same for the adult disability analysis. Here, the ALJ's decision essentially amounts to a finding that JF failed to meet his burden with respect to the adult disability analysis. He'd had no medical or mental health treatment as an adult. In fact, no treatment records after 2012 were provided, and it appears that none exist because JF denied being in any sort of treatment other than the special education supports that he received in school. On his mother's advice, he refused to cooperate with expanding the record. That was something that went up and down multiple times in the administrative record, in hearings across 3 different years. I would disagree with the sentiment that Ms. Cosenza and Mr. Freed are likely to agree to further record expansion. Even the educational records that we have in the record after 2012 were not received directly from the school. Rather, Ms. Cosenza printed out what she had. She submitted them to the agency and refused to submit anything else.
Was there any indication of why that happened? Or any finding as to why that happened? That they didn't exist, they wouldn't have been helpful, didn't want to be cooperative, all of the above?
There was a lot of back and forth between Ms. Cosenza and the ALJ, wherein Ms. Cosenza was debating sentence 4 versus sentence 6 remands under 42 USC 405G, and she was asserting that the record was complete, and with this type of remand, it shouldn't be updated. The ALJ repeatedly tried to inform her that the ALJ was required to assess JF's functioning as of the date of that hearing. She wouldn't cooperate. But at the end of the day, it is the claimant's burden to prove disability. Here, there is a complete lack of evidence of his functioning as an adult, other than the examination by Dr. Lana. I think we've detailed the deficits with respect to that examination and the allegations that JF made there, for example, about hallucinations and things like that, that he's never before and never again alleged, that reasonably called into question the results of that examination. So for all of these reasons, we'd ask that the court affirm.
Thank you, Ms. Payne. Ms. Meeks, we'll give you 3 minutes on rebuttal.
Very briefly, as to the commissioner's argument about the educationally based diagnosis of Asperger's syndrome, it was not in fact based on Ms. Cosenza's personal report to the school. Starting at page 28 of the appendix, the school psychologist, Karen Funk, performed testing, and the results from the Gilliam-Asperger's disorder scale are in the record. They found a high/probable chance that he suffered from Asperger's syndrome, but our point is that is not that the ALJ should have found a diagnosis of Asperger's syndrome. She found that he had a severe medically determinable impairment, and that was his learning disability. Our point in bringing up this evidence was simply that his teachers, the school psychologist, recognized that his behavior problems were not the result of his volitional choices, but they attributed them to this disability. Counsel also...
What's your best argument on the adult issue, other than Dr. Lana's report?
Sure. Ms. Cosenza testified that his condition was essentially unchanged. So beyond supplementing the record with additional medical evidence, his condition as an adult remains the same as it did as a child. And the ALJ herself found it, Special Appendix 69, that his medically determinable impairment was both severe and lifelong and was unlikely to change. There's also resource issues with this family. I think part of the reason that there's not additional medical evidence is that there are this type of care is expensive, and he received treatment as a child through the school psychologist, and that was why the family relied on those reports from school. The commissioner has argued that it's not clear how the behavior issues related to the domain of acquiring and using information. The ALJ concluded here that because his IQ scores fell in the low average range, but his grades were abysmal, they were consistently C's, D's, and F's all throughout his schooling, that he must be putting in a lack of effort because of this supposed discrepancy between his grades and his IQ score. But there's abundant evidence in the record, which I discussed in my opening, that the behavioral issues that caused the bad grades weren't simply volitional choices, but were in fact a symptom of the disability. So we thank your honors for your consideration and ask the court to remand for a new hearing before the ALJ. Thank you.
Thank you, Ms. Meeks. Thank you, Ms. Payne. The case will be taken under advisement. We are going to move now to Appeal 21-2284, FJAP versus Garland. We're going to begin with oral argument from the appellant, and we'll begin, Mr. Graver, with you.
Thank you, Your Honors. May it please the Court, Harry Graver for petitioner. I'd like to reserve 3 minutes for rebuttal. The Board's decision below rests upon a basic flaw. Where the Board was supposed to review the immigration judge's decision for clear error, it instead went about searching for a smoking gun. That was a square misapplication of clear error review, but as a result of that misapplication, the Board set aside a plainly meritorious claim. Before the immigration judge, petitioner proffered credible, individualized evidence to substantiate his CAT claim. That evidence showed that petitioner was someone who was personally targeted and extorted by the gang repeatedly. That evidence shows that petitioner was someone who rebuffed the gang and went so far as reporting MS-13 to the police. And the evidence shows that petitioner is someone who has already borne the cost of that insubordination, forced to flee to save his own life, and forced to endure the death of family members who could not do the same. In light of all of this, it was at minimum permissible for the immigration judge to conclude that there is a substantial risk that if petitioner was sent back to El Salvador, MS-13 would make good on its word and kill him. The BIA set all of this aside only by misunderstanding the record and conflating reasoned inference with unadorned speculation. At bottom, the decision below is an archetypal misapplication of clear error review. It is the sort of mistake this court has corrected before, and is the sort of mistake this court should do so again here.
I'm glad you began with merits because we can never lose track of merits. However, there's a very large jurisdictional issue here.
I figured there was a chance that, yeah.
So I appreciate your comments with regard to the merits. Why don't we get your thoughts on jurisdiction?
So jurisdiction, our basic point is that the status quo is neither broken nor in need of fixing. A reinstatement order becomes a final order once withholding-only proceedings are complete. This court then has jurisdiction under 1252 to review a petition of review, reviewing that reinstated order once it becomes final.
What are we to do with Bhaktavi Patel, the dissent in Ruiz, all of these cases that are telling us that we may not have jurisdiction?
So I think that with Bhaktavi or Bhaktavi, whatever, I think that the key defect there is unduly relying on the definitional provision in A47 and kind of using it as a shorthand. I think that's the essential defect with it, and also overreading Nasrallah and Johnson. I'm happy to talk about each in turn.
Please do.
With respect to the Second Circuit's decision, I think the key mistake there is that the board assumed under A47 that a reinstatement order becomes final once issued, because essentially what they said is that's when the administrative process is over. That's when it's administratively final. The difficulty is that the definitional provision in A47 doesn't control because it does not apply. It clearly contemplates BIA review, but there is no BIA review in reinstatement decisions. I think another key point is that the Second Circuit's decision plugs back into the whole statutory scheme quite poorly. First and foremost, with FARA, Congress established a clear policy that aliens are broadly entitled to CAT relief, and that CAT claims would be broadly reviewable in the federal courts. In so doing, it didn't distinguish between ordinary and reinstated proceedings. Instead, it used broad language. It used the term any person. There's two other indicia within the statutes, within the immigration laws as a whole, that I think confirm this understanding. The first is the Real ID Act. In the Real ID Act, Congress clearly presumed a single round of judicial review for CAT claims. There, too, it did not distinguish between ordinary and reinstated proceedings. But in neighboring provisions, and this is the second point, in neighboring provisions, Congress showed that it knows how to strip jurisdiction when it wants to. Look no further to A4 itself. There in the Real ID Act, Congress stripped jurisdiction of CAT claims in expedited proceedings. Congress knows how to strip jurisdiction over CAT claims. It did so with expedited proceedings. It did not do so with reinstated proceedings. And courts have been doing this for decades. There hasn't been a whisper in Congress that they've gotten this wrong. I would move then to, I guess, Nasrallah and then Johnson, I guess taking them in order. Nasrallah, of course, didn't involve reinstatement proceedings. It simply said that an order of removal is distinct from CAT. We completely agree with that. But it did not get into when an order of removal becomes final for purposes of judicial review. On that score, though, to the extent Nasrallah said anything, I think it only helps us. One is that Nasrallah affirmed that FARA is an independent grant of jurisdiction that extends to any person facing torture upon removal. Again, does not distinguish between ordinary and reinstated proceedings. And the other part is that Justice Kavanaugh was clear. He emphasized expressly, nothing in this opinion disrupts the existing authority of courts of appeals to review CAT claims. And at the time, everyone agrees that every court of appeals in the country would hear a case like ours on this posture. With respect to Johnson, Johnson involved different text. There, the issue is whether it's administratively final versus final. Ordinarily, when Congress uses different words, it has different meaning, and that rule should apply here in full measure. I think it's helpful to understand Johnson 2 in context. There, the question was about detention. When we're dealing with removal, there are two distinct issues. One is the whether question, whether you're going to send someone out of the country. The other is the where they're going to go. In the context of detention, it makes all the sense in the world for Congress to want someone detained once the whether question is answered. Once we've decided we're sending them out of the country, we want them detained in the interim. Congress uses the phrase administratively final as a shorthand for that. But final for purposes of judicial review is very different. For the reasons we explained in the brief, the way the statutory scheme works is that it becomes final for purposes of judicial review when the whether and the where questions are answered, and when the order of removal is ultimately legally operative.
What about, Mr. Graver, footnote 6 in Johnson? There's debate as to how certain the court was on this question.
So I think that, in footnote 6, they reserved the issue. I think what's telling about footnote 6 is that the court is keenly aware of this possibility. And
aware but not decide, is that fair?
Aware but not decide, but what I would point to a little bit as a telling sign is Santos-Zachariah. Santos-Zachariah reviewed a case in a posture like ours, something it could not do if the Second Circuit was correct, something it could not do if the authors of Nasrallah or Johnson thought they were subtly stripping jurisdiction.
Was that issue raised at all in Santos-Zachariah in any of the briefing? I didn't see it, and I know the Supreme Court can sua sponte take it up and has to assure itself it has jurisdiction, but I didn't see the Second Circuit's case or this particular issue highlighted or flagged for the court in any briefing.
So in Johnson...
In Santos-Zachariah.
Oh, sorry, in Santos-Zachariah, no, I don't think it came up. What we would emphasize, though, is that the majority opinion said, I think once or twice, at least once, that we have a sua sponte obligation to assure ourselves of jurisdiction. The circuits, I think Bakhtabai had already come out at this point. I think the circuit split was on the court's radar. Obviously, it's an implicit sign, but it's a telling enough sign that the Second Circuit decided to reassess its own positions. As the government had in its supplemental brief, they collected a couple of orders. So it's a hint nonetheless. I don't think it's something for us we're not hanging our hat on it, but I think it's a telling sign that the court was not trying in Nasrallah or Johnson to strip jurisdiction over a huge class of claims.
All this aside, the government suggests that we don't even need to reach the issue of jurisdiction. Do you agree?
Yes, we completely agree. I think that if anything, this is an easier case than Santos-Zachariah. There with the exhaustion requirement, that D1 provision is specifically directed to courts. It says courts may not hear unless administrative remedies have been exhausted. Here, it's a party-specific provision. It's just a deadline for filing a brief. Since 2006, I think it collected at least 4 examples where the court has said that those are kind of quintessentially non-jurisdictional claim processing rules. So I don't see that there's really a cogent or compelling reason for why D1 is non-jurisdictional, but B1 somehow is. So we are 100% in agreement with the government, and they've affirmatively waived it in our case.
How do we address the Supreme Court's opinion in Stone, where it said this was jurisdictional, if we want to go down that route?
So I think that Santos-Zachariah provides good help in that regard. With Stone, the idea is it's jurisdictional and mandatory. Finding the provision was jurisdictional wasn't essential to the case. Once it was mandatory, the question of equitable tolling was answered. I think that if Santos-Zachariah said nothing, it would be murkier ground. But the fact that they specifically called out Stone is a example of the court using the term jurisdiction loosely is quite telling, and I think would allow this court to take the best reading of B1.
Is that specific enough for us to not find Stone binding on us as to jurisdictional?
I think so. I think that
Because they didn't specifically overrule it or change it or say it doesn't apply.
I think that absent the court's own mea culpa, this would be tougher. But I think once the court has said, we have used the term jurisdiction incorrectly in all of our prior opinions, and they point to Stone as a key example of that in a case whose reasoning I think is irreconcilable with treating Stone as jurisdictional. I think once you string all of that together, this court is free to give B1 its best meaning.
And I checked yesterday. I have not found any court of appeals that has adopted this argument yet. I know it's a new argument. The government has switched its position and is now arguing that this is more of a claims processing rule than jurisdictional. Are you aware of any cases that have either adopted this or rejected it?
I'm not aware of courts weighing in one way or another. Obviously, Santos Zachariah is only a few months old, and
Right.
so yeah, I think it's a complete. With respect to B1 itself and Santos Zachariah, I think it's a blank slate.
I know it's percolating, but
I think it's percolating. It would be great, if you guys want to be the first.
I would like to return to the merits. I'm looking at our decision in cases like Brito and Estrada, I think it's Martinez, and, we said that you don't have to write, the BIA doesn't have to write an exegesis, they said, on every contention that they come across. So how much should the BIA say when they disagree with what the IJ has done?
I think that Brito is excellent. It puts its finger on the exact issue here, which is when does reasoned inference cross into undue speculation, and what is sort of the deference that courts are supposed to attach to the board's findings. I think Brito is correct that simply labeling something as speculative isn't necessarily a hallmark that the board is misapplying clear error. But at the same time, for the board just to say something is speculative without more doesn't insulate it from this court's review. I think this court assesses whether the board applied clear error much as it would assess how a district court or how a court of how it would apply clear error itself. I think there's a sliding scale depending on what's in the record, how much the board needs to say. But to the extent that it doesn't grapple with the facts, to the extent that it seems to treat its mandate for clear errors in more searching terms of review, I think it needs the basic dictates of reasoned decision-making need to be met. Here, on each 3 points, as we outlined, I think the board flunks that at each turn. I'm not saying that the board necessarily needs to write a novel for every single point. Some things are very clear from the record, but when there is strong record evidence, as there is in this case, the board needs more than what they did here.
Mr. Graver, if we find that the board applied de novo review or did not apply clear error review, do we still need to address the substantial evidence argument?
No.
Why not?
So the substantial evidence argument, I think, is sort of a fallback alternative argument that we have that, to the extent that you treat the board's opinion as a standalone order, it still needs to survive substantial evidence review as kind of a last resort. But foremost, the board's opinion rises and falls on its own terms. To the extent it misapplied clear error, the court has two options under Estrada Martinez. One is that this court can grant cat relief on its own. To the extent it's not inclined to do so, the proper course is to vacate remand with instructions for the board not to repeat the same mistakes.
Would you like to reserve the rest of your time for rebuttal?
Yes, thank you.
Thank you very much, Mr. Graver. Mr. O'Malley, we'll move to you now for argument on behalf of the appellee.
May it please the court, my name is Andrew O'Malley. I represent the Attorney General of the United States. This court has jurisdiction over this petition for review. Although recent developments in the Supreme Court have caused some confusion on this issue, an appropriate reading of the various authorities supports the conclusion that an individual like petitioner who goes through withholding-only proceedings must file a petition for review within 30 days after the conclusion of those proceedings.
This is a nuanced question. Is there any daylight between your position and the position that Mr. Graver's articulated?
Not really, not in those terms. We are in agreement as to the proper approach. I think this court has precedent saying that a reinstated removal order is an order of removal, which there was some question on that invoked by Patel, but this court has that precedent to fall back on. The question really is finality. And we think the proper approach is the approach taken by all of the circuit courts to address this prior to Bhaktabhai Patel, which is that the conclusion of the withholding-only proceedings, that's the end of the administrative process. That's when finality should attach in this instance. And we are in agreement, of course, that neither the statute nor Nasrallah nor Johnson v. Guzman-Chavez provides any real answer here. Nasrallah, of course, focused on
Provides any real answer on finality?
It doesn't provide any real answer on finality, right? It's whether the CAT order is itself an order of
Right.
removal. It doesn't get into finality, and the Tenth Circuit, in its decision, basically said Luna Garcia is consistent with Nasrallah. It just didn't. Nasrallah doesn't say anything that goes against that.
Judge Timkovich and Ide's concurrence was a little stronger than that, though, right? I mean, they were, but for Luna Garcia, they might not have joined Judge Matheson with regard to that point.
That's true, and that's correct. And the courts that have fallen back on this at this point are courts that have standing precedent that says that this is the way that you approach the 30-day deadline.
Is this court's precedent presuming that or outright holding that?
It is presuming that. I don't think that the court's precedent, I think it's Eker, Eck. It's not strong enough on that point to say that it's controlling here. But absent that, I think the proper approach is the approach that was taken prior to Bhaktabhai Patel and that the courts have fallen back on since, mainly because there's nothing that specifically answers this question. Again, not the statute, not the recent Supreme Court cases, and in that instance, we fall back on general principles of administrative law, where finality attaches at the consummation of all the proceedings. We fall back on the presumption of reviewability that attaches to immigration court proceedings, and the fact that the statute specifically provides for review of CAT determinations and withholding determinations. And of course, the zipper clause that says that all of these things are to be reviewed at the same time. These all demonstrate that the presumption of reviewability should attach here and suggests that we shouldn't preclude review of these withholding-only determinations.
What are your thoughts on this debate about footnote 6 in Johnson?
I think footnote 6, especially given the arguments that were made by the government at the argument for Johnson v. Guzman-Chavez, which is simply that there's something different here. There's something different between administrative finality for the purposes of detention and judicial review. I think footnote 6 is the Supreme Court stepping aside, and that is saying we're not saying anything about whether or not these are reviewable decisions. This is limited to the detention context. So I don't think that answers the question here. And again, in the absence of that clear precedent or statutory provision, we fall back on administrative law principles, the presumption of judicial review. To the extent that this may raise constitutional concerns, a candidate of constitutional avoidance would demonstrate that we should provide for review here. And also this fact that these are provisions that implement our international and treaty obligations, and we want the agency to get it right.
Would it conflict with the statute to find finality at the end of the withholding proceedings?
I don't think it conflicts with it, Your Honor. It's certainly even the definition itself speaks to order of deportation, and this is of course an order of removal. It was never fixed as we went through the process of providing for truncated proceedings like we have at issue here, or stripping jurisdiction away in criminal proceedings. Nobody ever went back and fixed this definition, and there's no indication that it was meant to, that development of the law was meant to strip jurisdiction of these issues. I don't think it specifically answers that question, and in that case we fall back on our principles.
Put to the side the horizontal stare decisis question in the Fifth Circuit in Ruiz. Why do you believe Judge Oldham's dissent reasoning to be incorrect?
In the Fifth Circuit?
In the Fifth Circuit, yeah. He dissents from Judge Smith's majority opinion, reasoning through that finality attaches to what he calls a reinstatement decision versus a reinstatement order.
Well, I think we go back to the functional equivalent analysis, that this is a functional equivalent of an order of removal, right? You can't avoid the reality that even if you get to the textual concern that an order of removal is the original removal order and this is just a reinstatement order, there is the reality that this individual is here, and this order of removal, or this order, is going to function to remove that individual. And I think that is where this court's precedent on that issue falls down, and I think it stands. There's nothing clearly inconsistent here. I'm sorry.
I was moving to jurisdiction
Okay.
now because you do argue in your supplemental brief that we don't need to reach it. And so why should we hold back? Don't we have an independent obligation to assure ourselves of our jurisdiction?
You do, Your Honor. I think you don't have to here. There's no real reason to get into that determination if you find that the 30-day time limit starts at the end of the withholding only proceedings. There's no reason to get into that matter because you would have jurisdiction anyway. And I would note, I'm sorry to take a side step to answer a question that you presented earlier.
It does, thank you.
The Fourth Circuit actually rejected the argument on the jurisdictional question on the whether or not the time limit is jurisdictional, but did so 2 weeks after the issuance of Santos Zachariah, without the benefit of our argument, and they didn't really grapple with the analysis in Santos Zachariah with respect to Stone. I'm sorry, I hope I answered your question properly, saying that there's no reason to get into it here if you find the 30-day time limit starts at the end of withholding only proceedings. We think that you can. We think the easier course is to go with the finding that the 30-day time limit starts at the end of withholding only proceedings, simply because it doesn't require this court to overturn any precedent. You're writing on a clean slate there. It's also that when the time limit starts, whether it's at the end of withholding only proceedings, is something that litigants need to know. So we think that that's the proper way for you to go in terms of deciding this case. But if you're not inclined to make that determination, you can find that Santos Zachariah is clearly inconsistent with your precedent holding that the time limit is jurisdictional. And at that point, we waive the application, even though we raise the timeliness question here, and the court should address this case on the merits regardless.
Why didn't you raise that argument before? The claims processing argument.
Santos Zacharias came out before
But
or
what
after
about
we filed our brief.
the Auerbach and Kui Feng Wong and the whole line of Supreme Court cases over the last decade that's made it very clear Congress has to give a clear jurisdictional direction in a statute for it to be jurisdictional, which is the principle you're relying on.
But that's absolutely, it's a fair point.
But it didn't come up in Santos Zachariah for the first time. That's my point to you. Why didn't you raise it before based on all this other precedent?
It's absolutely, it's a fair point. I think that the operative thing in Santos Zacharias is the discussion of Stone. Right? We had a clear precedent at that point up until Santos Zacharias with Stone saying this is jurisdictional. It's not so clear anymore, and I think Santos Zacharias directly conflicts with or implicitly overturns Stone.
Why the change in the government's position on jurisdiction? Is it just difference in policy perspective? It's unusual for the government to completely reverse the position it's been advocating and successful in. Why the change?
Well, for clarity, are you asking about strictly the jurisdictional position or the Bhaktabhai Patel position as well?
The Second Circuit.
The Second Circuit position.
Yes, yeah, because you've been advocating that for a while. You've advocated that in this court and a couple of other cases that have been argued before this one last term.
Yeah.
And the complete switch is surprising.
That's also a fair point. And I know it's unusual. I think we've had a chance to sit with the cases, to sit with Nasrallah, to sit with Johnson, Guzman, Chavez, and to understand their implications a little bit more. I think it's also the fact that at the Second Circuit, as my colleague notes, has started to make noise about reconsidering its position in Bhaktabhai Patel, not the least reason which is because of Santos Zachariah and the court taking jurisdiction over the withholding only claim like this. So I think
it's going to address that in two separate cases.
It's asked for briefing on that in two separate cases, and that happens, I think, in October. And I would note as well, in terms of the Fifth Circuit's recent decision, we've moved to extend the deadline to file rehearing in that case. They didn't have the benefit of this argument that we're presenting to you when they made that decision either.
So the procedural posture is PFR has been filed or PFR has not been filed in the Second Circuit case?
In the Second Circuit case, there's 2 PFRs pending.
Okay.
Those cases are awaiting briefing on this issue.
All right. And that's the October?
That's correct. I believe it's October that those briefs are due.
Thank you.
That's absolutely right. Turning to the merits, Your Honor, I think the board employed the proper standard of review here in overturning the immigration judge's CAT determination. The board articulated the proper standard, the clear error standard. The board explained that the IJ's prediction, a predictive determination that petitioner faces imminent risk of death, was clear error because it was based on assumptions and a series of hypotheticals. Now, when you have 2 permissible views of the evidence and one is okay, then the board can't substitute its judgment as to other. But the board's determination here is that the IJ's determination was not permissible. It was not a permissible determination because it's based on hypotheticals and speculation. And the board's determination shows, as it goes through why it made that decision, that it did not misapply clear error review. With respect to whether or not the petitioner was approached by a high-ranking gang member, the board determined that the evidence does not support that determination. Whether anybody has a continued interest in petitioner, the board determined that it was insufficient evidence to support that determination. And whether he's personally at risk, again, it was insufficient evidence. The board was not saying that they did not find the evidence persuasive, saying that there's no evidence here on which to make that speculative determination. And I think any review of the IJ's decision shows that to be true, where the IJ simply says, clearly this individual was approached by a high-ranking gang member. And obviously this individual is going to be at risk of torture in the future. But that isn't based on any facts in the record. The IJ's decision is short. Petitioner's counsel suggests that there should be a sliding scale with respect to the facts, but there's really no facts here. It's a really basic claim. It's a really bare-bones record, and the board's determination in that instance is sufficient here.
But is the board required to do a little more? Because when you look at cases like Brito or Estrada Martinez, and the board actually says more than it says here. Now, are you saying there was nothing more to say here because there is simply no evidence? Or was the board required to just do a little more to explain? Because if you just say there's insufficient evidence, you could get away with that and move on all the time and potentially move the goalpost in every case. What would be sufficient? That's the role of the IJ, sitting there with the evidence before him or her.
I think that's right, Your Honor. I think on the facts of this record, this board decision is sufficient. I think it does need to be based on the facts that are presented before the IJ and that the IJ relies on. And here, again, it's a bare-bones IJ decision with bare-bones facts presented to the immigration judge. And there's really nothing more for the board to say because there's nothing else presented.
What's your answer to petitioner's argument that if, these are permissible inferences that the IJ is drawing from what FJAP is telling the IJ? And so if it's permissible, since the board doesn't reweigh, the IJ's decision stands.
I'm sorry, I have 10 seconds. May I go over just a second?
Yes, ma'am.
Yeah, the fact is, again, there are permissible inferences, but this is not a permissible decision because it is based on speculation and a series of hypotheticals. The evidence doesn't show that leap in logic that the immigration judge is making. Clearly, he was targeted by a high-ranking gang member. The evidence doesn't show that.
So what did he need to show?
I think, I don't know what would have been sufficient to show that. That's really for the board.
And the BIA doesn't tell us either, do they?
They don't. But they do say that there's no evidence here to support those conclusions. I don't know what that evidence would be, but on clear error review, the board can say there is no evidence to support that determination.
Thank you, Mr. O'Malley.
Thank you very much.
Thank you. Mr. Graver, we'll go back to you. 3 minutes for rebuttal.
Thank you, Your Honor. So 2 points on jurisdiction and 1 on the merits. It was asked whether the Second Circuit's approach conflicts with the statute. I think the answer is yes. Congress clearly provided in FARA, as confirmed in the Real ID Act, that there should be judicial review over reinstated orders. The Second Circuit forecloses that as a practical matter, so it conflicts with the statute. There's a point about Judge Oldham's separate writing. I'll leave the second part of it aside since we talked about that before, about just when finality happens. On the point about why is a reinstatement decision in order at all, which is the first part of Judge Oldham's writing, this court has held for long that it has. Every court of appeals has. This court recently did in Lemos. And that makes good sense. It fits the definition of 847 like a glove. 847 says an order of removal is any order that orders removal. A reinstatement order of removal does so. You can look at the last page of the BIA's opinion. It says, further ordered, petitioner shall go back to El Salvador. So it is, reinstatement order is an order of removal. On the merits, without kind of getting into everything, I think that the high-ranking gang member is a useful point to focus on because I think it really captures the flaws of the board's decision below. I think it's undoubtedly permissible for the immigration judge, the fact finder, to credit petitioner's account. This has been petitioner's story from day one. It's what he told the police down there. People are saying there's no evidence in the record. There are 2 police reports. It's what he told the police down there. It's captured in writing. It's what he told immigration officials here. It's what he testified to below. And it's what the immigration judge found credible. What's important is that the BIA needs to play by its own rules. Under its own rules, testimony alone is sufficient. That's 1208.16. So once testimony is credible, once it substantiates a CAT claim, you can only set it aside if it's implausible on its own terms.
Is it enough, though, to draw the inference that it actually was a high-ranking member as opposed to he believed it was a high-ranking member? Because he certainly testified, he had the call, and he was told this is a high-ranking member.
Right. So I think that the inference is undoubtedly permissible because it's the only thing that really makes sense.
Which one? 'Cause there are 2 there. Is it sufficient to infer on its own that this was a high-ranking member?
Yes.
Why?
Because it's the only thing I think that makes sense of the course of conduct surrounding the episode. You recall that the petitioner was being extorted by the gang for months for $20, but here there's a huge change in conduct. You have 2 people come to his house, which is different, demand $2,000, which is different, and then threaten to kill his whole family, which is different, coupled with the whole cell phone episode. I think it makes all the sense in the world to think that that higher threat comes from a higher up in the gang, in particular because that's MS-13's MO, as the State Department report confirms. You have gang bosses in jails calling shots on the outside by way of cell phones. The other part of this, and I think this captures the real issue here, is it surely cannot be that the government's account is the only permissible account of the evidence, because the government would have it. You have 2 rank-and-file members of MS-13 decide on a lark one day to create some ruse with a cell phone. I think that just strains credulity. In no small part because they've been successfully extorting petitioner for months, and in no small part because it's MS-13. They don't need to do a Broadway shtick in order to ask for $2,000. They can just simply demand $2,000. So petitioner's been saying from the beginning, yeah, this was a high-ranking guy, and that this is what it seemed like to me. This is what I thought it was. That's why I fled. And I think it's completely permissible in the available record for the immigration judge to have credited that inference, and the board's decision to vacate it on threadbare reasoning was incorrect. I see that I'm out of time. Thank you.
Thank you, Mr. Graver. Thank you, Mr. O'Malley. The case will be taken under advisement. We're now going to move to appeal 23-1739, United States versus Darlene. Mr. Drysdale, is it Fiesta?
It's Feisty, Your Honor.
Feisty, thank you very much. And we're going to begin with oral argument on behalf of the appellant from Mr. Drysdale. Thank you.
Thank you, Your Honor. May it please the court, Tom Drysdale on behalf of the appellant, Darlene Feisty. Ms. Feisty suffers from severe mental illness. Nobody disputes that. Her mental illness has caused delusions that have resulted in her making various phone calls to local officials in the Bloomington, Illinois area for over 2 decades, none of which resulted in prosecution because they understood her mental illness. The question before this court is whether the federal government can force unwanted medication on her solely for the purposes of bringing her to trial, because everybody agrees she's never going to be cured. Now, this inquiry is governed by the Supreme Court's decision in Sell and its 4 factors. The 2 that I would like to focus on today are the government's diminished interest in prosecution and the district court's order that lacks the specificity that Sell demands. So, looking to the governmental interest, we concede based on the test used that this is a serious offense, which looks only to the statutory maximum that she's facing. But that's not the end of the inquiry. We have to ask also whether that interest has been severely diminished by the time Ms. Feisty has already spent in custody and the high likelihood of civil commitment in this case. So at this point, she was arrested in January 20th of 2022. So basically 20 months in custody already. And for the purposes of this inquiry, she's facing a guideline range of 12 to 18 months in prison. The government...
Mr. Drysdale, there's different courts of appeals have addressed the guideline calculation differently. And we have not specifically confronted how that factors in. Is that something that the court determines in determining the severity of the government or the government's interest, the first prong? Is that something that the court should look at in determining special circumstances to evaluate the importance of the government's interest? And does it really matter in the end?
Yeah, I think it's the latter, Your Honor. I think we look at it to evaluate the government's diminished interest in prosecution. These courts that have used it, Grigsby in the 6th, White in the 4th, Ruiz-Gaxiola in the 9th, they rightly recognize that the guideline range accounts for individualized circumstances. It says this is what this individual defendant is likely going to be looking at. It's not just this, 47 years imprisonment that the statutory maximum says, which we all recognize she's not going to get.
So it should be considered a special circumstance that the court would look at to weigh the significance of the government's interest?
To determine whether the government's interest has been severely diminished, even in light of the statutory maximum. And there's been some discussion here about guideline ranges, but what is undisputed is the government, not Ms. Feisty, the government proposed 12 to 18 months in the district court. They invited us to rely on it, they relied on it, and the district court relied on it. Everybody relied on it. So any arguments that it should be something different or that it's not the appropriate measure, those have all been waived. That is what the government told the district court to judge its interest by. And against 12 to 18 months, she's been in for 20. She's facing time served. So that's kind of prong one of the diminished interest. And when we look to prong two, civil commitment, yes, we focus primarily on her time served when we made our argument in the district court. But everybody recognizes civil commitment was the next step. The government told the district court, that's what we're going to do if you don't medicate her under cell.
I thought
really,
that, I'm sorry,
go ahead.
No, go ahead.
On the civil commitment issue, there really isn't much in the record on that. Whether or not she's likely to be civil committed, there really isn't much for the court to weigh. So how should we address that? And whose burden was it to come forward with that before the district court?
Well, Your Honor, I do believe that there's plenty in the record to show a likelihood of civil commitment. We have two doctors, her own doctor, actually, saying this particular individual cannot be released without being medicated. And that's what really distinguishes every case the government cites, because
Isn't
none of those
that
cases
going too far, though,
have-
Mr. Drysdale? Because weren't the doctors asked, they said they were not asked to opine on civil commitment.
They were not asked to opine on dangerousness for the purpose of civil commitment. I do agree with that. But they absolutely did both give the opinion that releasing her into society without medication is not appropriate. And that's
Is that
at the
standard
transcripts.
for civil commitment?
The standard for civil commitment is dangerousness.
Right.
But we don't have to show an absolute certainty of civil commitment, which is what the government seems to suggest. We just have to show a high likelihood, and the district court also has to weigh that factor.
So you agree you have to show that?
Correct.
You agree that the burden is on the defendant to establish a likelihood or high likelihood of civil commitment in order to diminish the government's interest?
I do, but I also agree that if you look at this court's opinion in De Benedetto, the district court is required to consider this factor, even if we focused on time in custody.
But
That's
it
what
still
the-
has to be,
That's okay. Did Judge Shatta do that, though?
No, at all. Not at all.
was he asked to, or was it raised before him? I understand that what we said in De Benedetto, that a court has to, but if it's not something you're arguing or not something where there's evidence saying she will be civilly committed or there's a high likelihood, what burden is on the court to address it?
There's certainly the government coming forth and saying, this is the next step if you pass on cell. And then there's this evidence of 2 doctors saying that she needs to be medicated. There's Dr. Sini, the government's expert, who said, I personally believe she's capable of carrying out her threats. Now, that's not she's dangerous and going to be civil committed, but it's more evidence in light of the government saying, look, Judge, this is literally what we are going to do.
So your position is it did come up. The parties did.
It did.
Raise it.
It was there. The government specifically said, we are going to take this step. That's in the transcripts for the cell hearing.
But you did not, you being the defense counsel, did not argue to the district court that there's a special circumstance of her likelihood of civil commitment that should diminish the government's interest, as you're arguing now.
We focused our inquiry on her
I think it was even more than that. You didn't raise this other issue as potentially diminishing the
It
government's
wasn't
interest.
specifically in our pleadings.
Okay.
But
So that's the question. If you didn't ask the court to consider that, what obligation is there on the court to address the argument?
And again, I would return to De Benedetto and I would go back to Sell, which specifically says the district court is indeed obligated to take these circumstances into account, particularly when the district court was clearly aware that this was what the government was going to do.
Do you have any examples of a waiver situation where a court has concluded that a party didn't raise it, whether or not that's actually true or not, and that functions as sort of a waiver such that the district court does not have to abide by its obligation in Sell and De Benedetto to discuss the likelihood of civil commitment?
I don't have an example of that, Your Honor. I think that De Benedetto basically answers that question. If it's in the record and it was broached, that's the word De Benedetto uses, broached. And if it was broached and it's in the record, the district court has to address it, and the court recognized that in its order. It recognized these are the 3 things that I have to take into account, and then didn't.
Before we lose the thread on dosage,
Yes.
any psychotropic medication of this nature is going to be medically administered. It's not going to be self-administered.
Correct.
Does the district court order have to get to the level of detail of saying what the dosage is, or can it just be medical administration of Haldol and that's all that's necessary?
I think every single court who has addressed this issue has been very clear that at bare minimum we need a range. We need a range something like 20 to 40 milligrams. It can't be what the district court wrote, which is any medication Dr. Sini wants at any dosage. That's what the district court has authorized here. I understand there was testimony about Prolixin at the hearing, but that's not what the district court limited it to. There is 0 testimony at the Cell hearing about an appropriate dosage. There is no treatment plan presented at the Cell
Let's
hearing.
put ourselves in
about
the district
dosage.
court's position, though. Judge Shadid is not a medical doctor.
Correct.
He's going to rely on the submissions from the parties. The government says this is what the order should say. Defense doesn't object. He enters the order. He's not going to. How can he do an independent review with regard to dosage?
Well, I disagree that we didn't object. We objected to any Cell order, and that included a governmental order that we didn't ask for.
I should have been more specific. A cell order with regard to the dosage.
Correct. And the problem is he can't enter that order. He couldn't because the government failed in its burden at the Cell hearing to elicit that testimony. This is the government's burden by clear and convincing evidence on every Cell factor. There is no question to Dr. Sini, who is the only person who has the authority and the expertise to testify about dosage, as what dosage or dosage range are you going to administer? The reason Judge Shadid couldn't do it is because the government failed to carry its burden at the Cell hearing.
Mr. Drysdale, if we agree with you on that and think something should be included in the order about the medication, to pick up on what Judge Brennan was asking, judges are not doctors. And certainly medical situations, especially with mental health, can be very fluid. What's the correct guidance that district court should have in terms of entering something specific enough, but not tying the hands of the medical professionals who are treating and in a much better position than a court to make that determination?
I do see my time is up, Your Honor, if I may.
You may.
Okay. I think in this case, the government is really stuck here because there's 0 testimony in
I
the
understand
record.
your argument, but if we agree with you and it needs further clarification, what's the guidance we should give that walks that line of, we don't want courts saying you should give this dosage, especially given if it were one time, one and done, that would be one thing, but it's going to take a period of time, and we want the medical professionals to have the flexibility that they need to properly treat the patient.
And I think that's where the opinion from all of the other circuits that come in that say, look, you don't have to pin down a dose, just give a range. Ask your doctors what an appropriate medical range is. Maybe that range is 20 to 40 milligrams. I'm not a doctor. But then the doctor can say, okay, what I'm going to do is I'm going to start with 20 milligrams. It doesn't work. I will try 25 and 30 and 35 and 40. And that gives the doctor the trial and error type of process that Dr. Sini testified to in this case to adjust the medications to see if it's going to work. But what can't happen is the government just failing in its obligation on dosage and then asking this court to come in and put 25 milligrams into the order based on a year-old order of something she got previously.
Thank you, Mr. Drysdale.
Thank
We
you,
will
Your
give you
Honor.
some rebuttal time.
Thank you.
Mr. Keenstra, we'll recognize you now on behalf of the government.
May it please the court. Good morning, Your Honors. Jeff Kinstra on behalf of the United States. The defendant waived objection as to the dose range and civil commitment, and the district court correctly held that important government interests are at stake in this case, given the seriousness of the charges, even considering any special circumstances. And I'll pick up where we left off with the dose range, and the first issue is that the defendant waived objection. The district court specifically asked the parties during the hearing, at a time where more specific testimony could have been developed, exactly what the parties were asking the court to determine with respect to the treatment. And defense counsel told the court, or agreed, that the parties were, quote, not asking the court to determine dosages and things of that nature. That's an affirmative agreement to the district court that the defendant was not seeking such a limit. And so, in doing so, the defendant waived her arguments on appeal that the district court erred.
That exchange seems to me ambiguous at best, because it is true, as Mr. Drysdale just pointed out, Ms. Feisty was objecting to the entry of any order whatsoever. So she certainly was opposed to a government drafted proposed order that the court hadn't asked for. The government just took it upon itself to supply to the court. She objected to the entire thing. She didn't want to be involuntarily medicated. Further in that exchange, the court is saying, you don't want me, the court, to get involved with, figuring out what dose is going to be. And both parties say, yes, for the very reason we've been discussing just now, judges aren't doctors, that testimony needed to come from Dr. Sini. Why is that not a fair reading of that exchange?
For a number of reasons, I think. The first is that the district court was expressly asking the parties what the parties were asking it to determine. So if the defendant's position was that the court didn't have to specify a particular treatment, but it did need to specify at least a dose range, that could have been the response to the court.
But that wasn't their position. They didn't want an order at all.
And so on that broad position, a generic objection to a cell order in general doesn't preserve every argument under the sun that could be made to the entry of such an order. And that's a very good point that the government did provide a proposed order. But that cuts the exact opposite direction, because that shows that the defendant had word-for-word notice of exactly what the government wanted the district court to order, and yet with that notice, the defendant said nothing in response about the dose range. They didn't say at that point, when they knew word-for-word verbatim what the government was requesting, they didn't say that, no, actually, Your Honor needs to include the dose range.
Now let me ask you the same question I asked Mr. Drysdale. Do you have a case, an example of the waiver that you're suggesting, where a court, we have said or another circuit has said, a district court doesn't have to make these required cell findings, or doesn't have to do what we said in Di Bendito, which is, address civil commitment, et cetera. Do you have examples of that?
Yes. First, it's well established among the courts of appeals that cell orders are subject to forfeiture. Cases like Cruz and others. Mm-hmm. Cruz, in terms of waiver specifically, said that objections to cell orders invite consideration of traditional notions of issue preservation, forfeiture, and waiver. So Cruz eventually applied forfeiture because there was not a waiver there, but it said that the traditional notions of issue preservation apply equally to cell orders. As to medication, I would note that this court has enforced waiver against supervised release conditions that ordered a defendant to take whatever medication was prescribed to them by their treatment provider. Beyond that, as to Di Benedetto, the issue was raised there by the defendant. In fact, the defendant in DiBenedetto pressed the point so forcefully that the district court, in fact, thought that the defense counsel was seeking civil commitment. So it's DiBenedetto. It was not just stating in a categorical rule that in every case a district court must raise civil commitment, even if a defendant doesn't. Defense counsel here concedes that the defendant, in fact, has the burden of raising that issue. And in DiBenedetto, it was raised to the district court. The defendant themselves raised the issue of civil commitment. Here, the defendant took the exact opposite track.
On the dosage issue, for your waiver argument, you are relying on an exchange during Dr. Opaso's testimony. And if I read it correctly, his testimony, the discussion wasn't about a treatment plan. And he was a psychologist who couldn't have opined on medication and dosages anyway, wouldn't have been qualified to.
That's correct.
But there was no such exchange when the two psychiatrists testified. Mm-hmm. So how should that impact our waiver analysis?
So I don't think it does cut against the government's waiver arguments. Dr. Opaso was the first of the three experts to testify, and the district court was asking a couple questions before the testimony began and also during the testimony about basically what are we doing here, what are the disputes between the parties, what findings are you asking me to make? And so this particular question did come up during Opaso's testimony, but given how clear the parties were, and they expressed agreement on this issue, that they weren't seeking the district court to determine dose ranges.
I'm not sure the defendant agrees with that.
And I rely on the transcript. The transcript says, we quote, the parties are not asking the court to determine dosages and things of that nature. The defense counsel's response is correct. As to the issue about waiver, I'd add that waiver is a rule of general application. The Third Circuit in Cruz said that it applies equally to sell orders as in any other context. And I think it's important to add as well that enforcing a waiver here does not leave the defendant without recourse. The district court's order expressly held open the opportunity for any party at any time to seek a modification. So if the defendant or her experts come to believe that a particular limit is necessary in order to ensure that the treatment remains appropriate, they're free to go right back to the district court and ask the district court to make that inquiry.
But I think the concern behind that is, and the reasoning behind the court putting a range in, is to protect the defendant, that the doctors, that they want to keep them, to protect the defendant, to make sure she's not over-medicated or they don't do something different than what they've represented to the court.
And I think that is part of the concern. As this court noted in Breedlove, the circuits that have asked for more, it's typically been an issue where there simply wasn't enough in the record for the district court to even make the findings at cell 2 through 4, the cell 2nd through 4th factors. That's not really the issue here. As to protecting the defendant, as soon as this court were to affirm if it were to do that, the defendant could come back and ask the district court to set a limit. I imagine that the experts could get their heads together and do that. But really enforcing a waiver just ensures that the litigation proceeds in an orderly process, that just as with conditions of supervised release, for example, that the defendant presents their claim in the first instance to the appropriate decision maker before asking this court to weigh in on it. As to, I guess there are a number of issues to address as the important government interests. I'll start with civil commitment. The defendant has conceded this morning that the defendant does have the burden. The defendant never raised it in the district court. And in fact, it's a more fundamental problem because the defendant didn't just not raise it. At every opportunity, she argued that she was not dangerous at all. This morning, my friend on the other side's first comment was that she's been making threats for decades. And yet, as she argued in her briefing below, the authorities have never civilly committed her, never deemed her dangerous. This was a repeated, insistent thread that the defendant made in the briefing below. And in arguing that she was not dangerous at all, she has waived any argument on appeal that she is so dangerous as to be likely civilly committed. Beyond that, really the record here is uncertain. I add that the defendant misstates the testimony in asserting that multiple experts or both experts have opined that she cannot be released without medication. In each instance, she cites the same expert's testimony, Dr. Byrne. So it's really just one expert, not multiple experts. And as your honors have recognized this morning, the testimony was not that she would be dangerous if released without medication. It was that from a clinical standpoint, she should be medicated, even if that requires an order to do so. Beyond that, there are no expert opinions on dangerousness or civil commitments, and so at best, we have an uncertain possibility.
So how do we factor in the other special circumstance here that really was the focus? I'm troubled that the guideline range is 12 to 18 months here, and she's already served roughly 20 months. If we affirm the cell order, it's going to take at least 4 months, maybe more, to see if she can become competent to stand trial. Then to get the trial scheduled, there'll be more delay. By the time she goes to trial, we're probably talking about another, at best, 9 months, maybe more. That's troubling, because then she's going to be serving time at twice what the high end of the guideline range is. How do we factor that in to the analysis here?
Sure. So I think we start at the step one that my friend on the other side conceded, which is that the government interests here are very strong. And as Sell emphasized, a special circumstance like pretrial detention is not a substitute for prosecution. It may lessen the extent of those interests, but when we have such a strong starting point here, even when those interests are lessened, the interests that remain are still important. And
you've distilled your interest to a firearm prohibition and supervised release.
Well, it's not quite that limited. As we argued, and as Sell acknowledged, first, there's an inherently strong government interest in prosecuting serious offenses. That doesn't go away when a defendant reaches a sentence of time served. We identified a number of other interests that don't depend on the defendant receiving a sentence that extends beyond the date of sentencing. That includes protecting individual security, given that these are threats of violence against people, protecting the government itself and government officials, protecting the government's integrity and protecting public trust in government to show that the government will not be influenced and will not be deterred in carrying out its duties by threats of violence of these sorts. There's a very strong general deterrent effect. As to this particular defendant, there are important interests in terms of supervised release, which would protect the public as well as promote her rehabilitation, both through the monitoring that supervised release allows, as well as that it would allow the probation office to ensure that the defendant is receiving appropriate mental health treatment and services, which could include medication. The supervised release, as I just mentioned, and the firearm are part of that, but these are broad interests, and the government has, at the outset, a very strong interest in prosecuting these sorts of offenses that target the government itself. I see I'm way over time, so.
Thank you, Mr. Keenstra.
Thank you.
Mr. Drysdale will give you 3 minutes on rebuttal.
Thank you, Your Honor. I'm going to go ahead and just read from the transcript on this waiver issue. Judge Shadid said, I guess what I'm asking, though, is if I find that she should be involuntarily medicated, then are you guys asking me to decide based upon what I hear what the course of treatment should be? Or, once I've made that decision, that course of treatment is going to belong to the experts, correct? Mr. McMyer, correct, Your Honor. We're not asking the court to determine dosages and things of that nature. Ms. Douglas, defense counsel, correct. That's clearly an exchange where the district court is saying, look, am I going to be a doctor here, or am all I doing is making a determination that she should be involuntarily medicated? Then you, government, have the burden to elicit from your expert what that course of treatment should be. That's what the exchange here, that the government is relying on solely to say that we waived our right to have a safe and effective medication dosage. And
when would that have occurred if it's under your reasoning? When would that opportunity have occurred to have it if it wasn't that?
When Dr. Sini testified, Your Honor, the only expert in this case who, by everybody's admission, could say, here's what the medication dosage is.
But isn't that exchange you just read happening after that?
No, it's not. It's before.
All right.
And so the government should have, when Dr. Sini came up, said, okay, you want to administer Prolixin. What dosage? Or what dosage range? How much? For how long? Is it just Prolixin? Instead, we have an order that just lets Dr. Sini basically do whatever she wants.
What about the other psychiatrist? Why couldn't that doctor have opined?
Because Dr. Opeso himself said, look, I don't do meds. I can't do meds. I'm just a psychologist.
But there was another psychiatrist who testified.
Our psychiatrist did,
okay.
but it's not our burden to come forth with the medication dosage. So, and I think I'm offended by the notion that you can waive your right in general to a safe medication dosage. That can't be the law. That can't be cell. That can't be due process. So the government has to comply with that burden. And, the government has said a lot about waiver this morning, but, let's enforce waiver then on 12 to 18 month guideline range. So we have all this discussion about civil commitment, but we don't even really need to get there because, as Judge St. Eve rightfully pointed out, the government is seeking a sentence that's going to exceed 2 years against a guideline range of 12 to 18 months.
Mr. Drysdale, I don't think that's fair. We don't waive our way into sentences.
Well, Your Honor, I think it is fair. I think when the government comes and they say, judge our interest by a 12 to 18 month guideline range, I think it's very fair for the government to invite the district court to do that and for everyone to look and say, okay, against that guideline range, the government's interest is severely diminished in this case.
Judge Shadid reserves the right to have the sentence at the end, not the guidelines.
He absolutely does, but that is a separate question as to whether the government's interest has been severely diminished for the purposes of injecting Ms. Feisty against her will. Thank you, Your Honors.
The case will be taken under advisement. Thank you to Mr. Keenstra. Thank you to Mr. Drysdale. We're going to move now to case number 5, Appeal 23-3219, United States versus Medrano. And we're going to begin first with argument from counsel for the appellant, Mr. Arnaiz.
Thank you very much. May it please the court, my name is Ivan Arnaiz. I represent Elvis Medrano, the defendant. This is a case where Mr. Medrano believes the court committed error when it allowed a statement from a non-testifying declarant in the form of a text message. Mr. Medrano's contention is that the text messages were an arm's-length conversation concerning a drug deal as opposed to an agreement between parties that are working together to further a conspiracy. This is a case where the declarant, Mr. Marshallton, tells Mr. Medrano, after Mr. Medrano says he has drugs for sale, I can get it from someone else at a better price. It is Mr. Medrano's contention. In this case, we're not cooperating together. He's trying to get the better end of the deal. And then negotiations come about in which, again, the parties aren't cooperating together. Each is trying to outdo the other, which would infer they're not trying to further the ends of any agreement. They're simply trying to get the better aspect of a transaction, which is more in line with a one-time drug deal.
Mr. Arnaiz, can I
Yes,
clarify,
ma'am.
please? You're asking us to remand for a new trial in
Correct.
light of the admission of this evidence.
Correct.
There was a drug conviction. There was also an ammunition charge and conviction. Do you agree that even under your argument, the admission of this evidence would not have impacted the ammunition charge? You don't address that in your brief.
No, I do not, Your Honor.
So do you agree that the ammunition charge would stand regardless?
Correct.
Okay, so it would go back for a
For
new trial.
sentencing.
If you are successful, it would go back for a new trial on the drug conviction only.
Correct.
Okay, thank you.
It doesn't even matter. You just mentioned that the text suggests a one-time deal between Medrano and Marshallton. In our circuit, does that even matter? We're not a circuit that says anything above a one-time transaction must be a conspiracy. In our circuit, you can have a buyer-seller relationship with more than one transaction.
Correct. The problem is, if we were to define conspiracy so broadly that a customer buying drugs from a dealer can put them into a conspiracy, then we may have drug addicts get into things they never contemplated. To get into a conspiracy, you have to contemplate working with another and entering into their conspiracy. But in this case, we have Mr. Marshallton, who's basically trying to better the deal for himself. Mr. Medrano, who's trying to better the deal for himself, which again does not show any working together to further the goals of a conspiracy, which is let's get together and help each other sell drugs. In this case, they're actively trying to do better than the other. In addition, in this circuit, let me pull it out, we have a rule where a one-time deal itself is not enough. But you can couple that with ongoing deals, ongoing understandings, things that somewhat become standardized, ways of doing business together. In this one, all we have are two people simply trying to outdo the other so that each can walk away and do better than the other. Again, the key in this one is I can go somewhere else and get it. There are people I can get this from. And then Mr. Medrano uses some fluffery, not this good. In addition, we have the word front that is used in this one. But simply using the word front doesn't mean much unless there's other circumstantial evidence behind that word that might lead to a history of working together, wholesale dealing, agreements where we say, if you give me this, I'll pay you this. Mr. Marshallton was very clear in his text where he said, I can pay this much, and I can also get some good marijuana for you. He used a slang term for that, which infers, here's my payment, and here's the payment represented as a different sort of payment, more drugs. Now, in the text, if you read them, one person might say, well, it looks like he's saying, I'll sell the drugs you give me, and then I'll pay you back with the proceeds. It is Mr. Medrano's contention that the statements there were, the guy gave himself his own deadline, I'm going to pay you no matter what, which means that he's going to get the source of money for what he owes him from other sources and not directly for the drugs themselves, which again would be more in the form of a drug deal between two arm's length participants.
Can you address harmless error? Because even if we agree with you, the next step we have to assess is harmless error.
The problem in this case is there are no wiretaps. Nowhere in the record do we hear Mr. Medrano talking to people. Everything comes in the form of cell phone texts. Cell phone texts themselves, well, who knows who's actually texting? This is a case where none of the packages were sent to Mr. Medrano's house.
Well, you do have cooperator testimony here.
Yes,
and those cooperators testify about their conversations with your client.
Correct.
In great detail.
Yes, these are people who were getting the packages, arranging for the packages, doing the brunt of the heavy lifting, but they've also got agreements where it was in their best interest to put the blame on someone else or color their own testimony in form of bias so that they can get better deals for themselves.
Wouldn't Mr. Medrano's attorney below at trial have raised this with the jury?
This was raised with the jury.
And the jury decided the other way?
Yes, but the argument at the jury below was, if you look at all this circumstantial evidence tying Mr. Medrano to this case, you still only have one piece of evidence, and that's the text. Without that text, this case
What
would
about
not...
the searches of his hotel rooms where drug paraphernalia was taken, drugs, other things?
Well, I agree that is a weakness.
Evidence. Yeah,
Yes.
and twice, two separate hotel
Correct.
rooms.
Now, in these hotels, he wasn't the only one there.
You may continue.
Okay. Now, the point is, these things that were found at the hotels, strong circumstantial evidence. But again, this was the only conversation where the text was put in, where Mr. Medrano is offering dope to someone else, negotiating a price, they claim showing it to someone else, and goes on to describe how good it is. Without that, the jury could have said, it's a circumstantial evidence case, but we don't think there's enough. So it
You
is
want to
his.
reserve the rest of your time for rebuttal?
I do not, Your Honor. I
All
think
right,
I've
you
said
may
everything I
continue.
need to say. Okay.
All right, thank you.
So it is Mr. Medrano's contention that this text that came in was very prejudicial. It is a text of a 403 nature where they can form a view of Medrano that otherwise would not have been there but for the words themselves where he's describing a rather vulgar transaction. If that did not come in, the jury could still say, well, we don't have wiretaps, I don't hear his voice, nothing was sent to him, everything sent to everyone else. Everyone testified and told us on the stand, I'm doing this so I can get the best deal possible. But I believe even common people know, and the courts know, that when bias enters a picture, a person's almost willing to shade their testimony in any way they can to get the best results. The problem is it becomes very unreliable testimony in that it would be the same type of testimony coming from a used car salesman who is putting fluffery in front of his sales pitch in order to sell a car that might blow up 5 miles down the road. And that's the problem in this case because all the evidence basically was very circumstantial where fingers were pointed from people who had an interest in their own outcome, not exactly Mr. Medrano's outcome. But this text was perhaps the most direct evidence tying them to this conspiracy. Otherwise, the jury could have seen him as just another drug dealer, and that's it, outside of the conspiracy with these other people.
Thank you very much, Mr. Arnaz.
Thank you very much for your time.
We'll now move to Mr. McGrath on behalf of the appellee.
Thank you, Your Honors. May it please the Court, my name is Jason McGrath and I represent the United States of America. We are asking the Court to affirm the District Court in this case. Before I get to the structure of my argument, I just wanted to make a quick comment on the appellant's argument as it pertains to the statements in the question text messages. Mr. Medrano's half of the conversation comes in under a statement of a party opponent in any event. It's the statements of Mr. Marshalltown that we're looking at as far as statements of being a co-conspirator. So all of the statements made as far as pricing, the picture of the methamphetamine, and all the things that are in the blue boxes in the exhibit, those are from Mr. Medrano because that actually was authenticated as his phone through specific records from the phone company and other circumstantial evidence, as we can see in the records. So that evidence in and of itself is pretty damning. It's the overall statements from Mr. Marshalltown that are really the subject of the question. And the government believes that it proved at the trial court that by a preponderance of the evidence that those statements were admissible under 801 D2E because it met all three prongs of that evidentiary standard. The first prong is that a conspiracy existed. There was evidence throughout the trial of Mr. Medrano's involvement with several co-conspirators as far as the bringing in of drugs and the use of a postal employee to provide a safe haven for those drugs.
Is there any evidence that Mr. Marshalltown was involved in this broader conspiracy?
So, to answer your question, there is, in the text message themselves, that is going to be a lot of the evidence against Mr. Marshalltown as far as being a conspirator.
I think that's the only evidence against Mr. Marshalltown, isn't it? I didn't see anything else in the record that Mr. Marshalltown's name came up at all.
His name did not come up at all. In fact, that's probably an alias. He was unindicted, and he was not necessarily mentioned until the context of these text messages came up.
So is there any other evidence that he was involved in this broader conspiracy?
As far as the broader conspiracy, whether he knew any of the other indicted co-conspirators, no. But as far as being involved in a conspiracy, then I believe that there was evidence to support that given the situation with Mr. Medrano and the top-down structure of the conspiracy itself. You would have the drugs being shipped from California, you would have them being received by Mr. Martin and Mr. Medrano, and then those drugs would then be distributed in the various Southern District of Indiana communities, and Marshalltown can be implied, or at least inferred, from the evidence that was recovered as far as the tracking of the packages, the physical evidence from Mr. Medrano's apartments, the ammunition, the statements of the other co-conspirators, that Mr. Marshalltown was an arm of this conspiracy to receive, sell, and resell drugs into the community.
But to make sure I understand your answer to Judge St. Eve's question, your only evidence about Mr. Marshalltown comes from this text message.
We would not have known about Mr. Marshalltown at all, except for the text messages and the evidence inside of those text messages as far as him being a conspirator. But I think the court can consider the statements themselves. There has to be independent evidence. No doubt there has to be independent evidence that a conspiracy existed and that Mr. Marshalltown was a member of that conspiracy. When I was answering Your Honor's question, I was thinking more along the lines of the evidence recovered throughout the course of the trial established, number one, that there was a conspiracy, and then the inference can be made that Mr. Marshalltown was a member of that conspiracy, or at least an arm of that conspiracy to, I guess, dilute and
where's your
distribute the drugs.
independent evidence? Is it only the statements of Medrano in that text message? Is that the independent evidence for Marshalltown being a member of the conspiracy? What's the independent evidence?
I think the evidence recovered and admitted in the trial is the government's position that that would be the independent
Of
evidence
Marshalltown
being involved. And then the inference from what Mr. Medrano was communicating to him through his own statements and what ultimately the statements of Mr. Marshalltown itself, which again can be considered in this analysis. The government's position is the independent evidence was basically throughout what was admitted during the course of the trial.
And none of that mentioned Marshalltown. Everything else at trial, none of that, and that's the independent evidence, that the evidence that does not mention Marshalltown.
Correct. And just to address what I think your concerns are, when we're looking at the type of ruling that this was, and I don't mean to presume, I think if Mr. Marshalltown was sitting in that defendant's chair, and they were trying to charge him with conspiracy in this case, I don't think that would have been sufficient to get him into that conspiracy. But as far as an evidentiary ruling on this particular narrow issue where the prongs had been met, the standards preponderance of the evidence, there was a reasonable basis for the judge concluding that these statements were made in furtherance of a conspiracy. I believe that there was sufficient independent evidence that the district court looked at in the totality of the circumstances throughout the entirety of the case and evaluating what that evidence meant in the context of these statements.
Let me ask you something else. In your brief at page 24, you, in defending the judge's evidentiary ruling, you say, look, the district court wasn't a rubber stamp on these evidentiary challenges by Mr. Medrano. At another point in time, the court considered a similar evidentiary issue and ruled in Mr. Medrano's favor.
Yes.
So it sounds like you're saying, you know, we should consider that the district court did not abuse its discretion with this Marshalltown situation because in another instance in trial, the court ruled in Mr. Medrano's favor. Do you have a case where we took something like that into account when deciding an evidentiary issue?
I don't have necessarily a case on point with that specific question. I believe when I was writing that and drafting it and submitting it, it was more in the context of the abuse of discretion standard as far as special deference given to the evidentiary rulings of the trial court and the abuse of discretion standard met only when the trial judge's decision is based on erroneous conclusions of law or where the record contains no evidence on which he rationally could have based that decision. And when I referenced the other exhibit, it was merely to emphasize that the judge did rationally look at these exhibits and apply the law appropriately and did not abuse discretion in admitting the Marshalltown text because the judge demonstrated that capacity in the other exhibit. So that's merely the reference. It's not an either-or principle, and I wouldn't presume to cite a case that would suggest that. It was more just to emphasize, okay, this judge looked at the evidence, decided that there was a reasonable basis, that it was proven by a preponderance of the evidence that it could come through, and just made the ultimate decision. I think ultimately what I would like to close on would be that In any event, this would be harmless error, as the court touched on before. It is a constitutional challenge. There's a Crawford challenge here as far as the admission of those statements. However, even constitutional errors can be harmless, particularly if the challenged evidence does not contribute to the verdict beyond a reasonable doubt. And it's the government's position that the evidence of everything that was recovered from Mr. Medrano's hotels, all the electronic evidence as far as him tracking packages, communicating with others that were involved in the conspiracy, direct testimony from cooperators and other civilians, as well as all of the paraphernalia and the trade and tools of the trade as far as drug trafficking goes. All of this supported beyond a reasonable doubt that Mr. Medrano was guilty of conspiracy as charged in count 1, as well as the ammunition count, which, as Your Honor pointed out, would not be remanded for a different verdict. The admission of the Marshalltown text simply did not have the effect to sway the jury the way that the defendant has described it, based on the avalanche of evidence and the totality of everything that was submitted throughout the course of a 4-day trial. It was merely a drop in the bucket, as I stated in my brief, as to the overall evidence in the case. Therefore, any admission, even if it was error, which we contend it wasn't, but even if there was error, was harmless. I would cede the rest of my time if there's no additional questions. Thank you, and again, we ask that the court affirm the district court. Thank you.
Thank you, Mr. McGrath. Thank you, Mr. Arnaz. The case will be taken under advisement. We'll move to our final case of the day. This is appeal number 20-2639, Martel Flippins versus Wexford Health Sources. We'll begin with argument from the appellant, Mr. Hayes.
Thank you, Your Honor. I'm Eldon Hasek, counsel for the plaintiff appellant Martel Flippins, and I would please ask the court to reserve 3 minutes for rebuttal. In the district court, Mr. Flippins was pro se, and he filed a lawsuit after 2 years of denial of a hernia surgery that had been recommended by the prison doctor. But his case was dismissed for not responding to a show cause order, but the show cause order was sent to the wrong address. During the pendency of the lawsuit, Mr. Flippins was released from prison, and he changed addresses multiple times. And in February 2020, it's page 5 of the short appendix, Mr. Flippins asked that the court use a more, in quote, a more permanent mailing address in Gary, Indiana, which was his mother's house, instead of the halfway houses where he had been living and had changed addresses multiple times. But the clerk of the court did not update the docket with that address and instead used the address where he had mailed it from. And from that point forward, Mr. Flippins did not receive case documents from the court. The only document he received was a notice of withdrawal from one of the attorneys for one of the other parties who had used the address that he'd put in the body of his letter. And so when the court issued...
Is that the same attorney he then contacts for an update on the case?
So it was a different attorney because that attorney withdrew.
Okay.
I don't recall who that attorney had represented. There were multiple defendants in the case at that point. And that was in May of 2020. So the district court had been closed because of COVID. That also happened at that time. And so when the court essentially reopens in June, the judge issued a show cause order, but it was mailed to the wrong address. And then when the court didn't receive a response, it issued a second show cause order titled a notice of impending dismissal, which was also mailed to that incorrect address in Chicago. And so Mr. Flippins never received these show cause orders. They were never sent to the correct address. And so we therefore asked the court to reverse the dismissal and restate the court because he never received notice of the dismissal. Now, under this court's precedents, namely the Johnson case, a pro se plaintiff, a district court cannot dismiss a pro se plaintiff's case for want of prosecution without giving an explicit warning that the case may be dismissed for not following orders. But in this case, the orders were never received, and that is the key problem.
Should it matter at all here that a Rule 60 motion was never filed before the district court to have the district court cure any potential error? Because it doesn't look like the court was aware of this error.
So I agree, Your Honor. So in the order of dismissal, it appears that the court is under the impression that its show cause orders were sent to
Yes.
And so I don't think it should matter that a Rule 60 motion was not filed. Mr. Flippins could have filed a Rule 60 motion, and perhaps that could have cured this error in the district court. But he chose to file an appeal instead, and it was appropriate to file an appeal because there was a final order. A final judgment was issued, and he filed it with timely. And so there's no issue with this court taking jurisdiction of this appeal or any preliminary step. The Rule 60 option could have been used, but again, Mr. Flippins was pro se, and he instead chose to file an appeal, which was perfectly fine under the rules.
Do you want to address, Mr. Hessek, the prejudice question? Whether or not the defense here has been prejudiced as a result of any delays that Mr. Flippins might have been responsible for?
Sure. So we cite the Palmer case in our briefing. In the Palmer case, this court said that a delay of 9 months is considered young, that the dismissal after 9 months for failure to prosecute is too soon. Now, in our case, it's 14 months, but I think it's important to note that within that 14 months, the last 3 or 4 months cover the COVID pandemic, where there were inherent delays to the court system. And we also have, so the case started, the lawsuit was filed in May of 2019. Mr. Flippins stopped receiving notice in February. And so any time after February would not, it's not his fault since he wasn't receiving notice at the proper address. And I think that the question of prejudice really goes to loss of evidence, loss of witness testimony, things of that sort. But in a case of this kind, the defendants hold all the evidence. They have the medical records because it's within the prison system and what they have. They're aware of the lawsuit, they're aware of the grievance and the claims, and so they're basically under a duty to preserve evidence and witness testimony. So there's really not a prejudice to the defendants in that regard. Additionally, the motion that Mr. Flippins did not respond to was a summary judgment motion filed by the Illinois state defendants who are no longer in the case. They filed a motion on the issue of exhaustion. The Wexford defendants, who were the last remaining defendants in the case, did not join that motion. It does not apply to them. And so I think that also goes to the question of prejudice, is that in essence, when the court dismissed the entire case, the Wexford defendants received a windfall because they never moved to dismiss the case on summary judgment. The case simply went away. And so it'd be unfair to call this prejudice when they basically got a free dismissal. So we asked the court to remand the case back so that Mr. Flippins has an opportunity to conduct discovery and prosecute the merits of his case. And because the court can and should correct this clerical error that occurred and that Mr. Flippins suffered as a result of. And I would reserve, unless there's further question, I would reserve the remainder of my time.
Very good. Thank you very much, Mr. Hessek. Ms. Meltzer will now move to you for argument on behalf of the appellee.
Thank you very much, Your Honors. Good afternoon. My name is Catherine Meltzer on behalf of the appellees. May it please the court, this is a case about personal responsibility and the responsibility that every litigant, regardless of their represented status, has to the district court to prosecute the case that they filed and to adhere to the court's orders. Mr. Flippins did not prosecute the case that he brought when he filed it on May 16, 2019. He ignored a motion for summary judgment on exhaustion of administrative remedies filed by the Illinois Department of Corrections. He then did not adhere to the court orders to ensure that the district court had his most up-to-date address, and he did not respond to the court show cause orders.
How can you say that when given his letter to the court that clearly included the proper address?
I believe Your Honor is referring to his February 7th, 2020 change of address, which is the crux of this case. I can say that because the February 7th, 2020 change of address was signed Martel Flippins at a Huron Street address in Chicago.
But it makes clear in the body of it that he has moved and that his permanent address is in the body, not below the signature.
And Your Honor is focusing on the second line of the February 7th change of address, but I would direct the court's attention to the first line of the February 7th change of address, which actually says, I moved to a different halfway house still located in Chicago. And then he signed it Martel Flippins from the Huron Street address in Chicago, Illinois. He had moved 2 prior times, one to a Calumet City address and one to an address at 113 Place. In both of those prior changes of address, he'd signed the change of address from the location that he was. So I believe it was absolutely reasonable for the district court and the district clerk to believe that he was sending this change of address from the Huron Street address in Chicago and to believe that that was his correct address.
If we agree with him that he correctly sent the change of address in and it was just docketed wrong, an honest mistake, but a clerical mistake at the district court level, do you agree we should send it back?
No, I do not agree that the court should send it back. And the reason for that is Mr. Flippins still retained a duty to monitor his own case. He was released, I believe it was in August of 2019. He was no longer incarcerated. He had access to the court's online docket. We know he had access to the internet. And I believe that it is still his responsibility as litigant to monitor his case, to be aware of what's happening in his case, and to prosecute his case. And he did not do that. It appears that after he filed his change of address, then he did nothing with the case to check what was being filed, what was happening. He apparently didn't call the clerk or call the court and ask what was going on. He did nothing to prosecute his case, and that, I think, is why it should not be sent back, even if this court does accept that there was an error made by the district clerk with the mailing address.
If the defendants had taken this amount of time, would a default have been entered against them?
Taken the amount of time to respond to a court order or respond to, yes, I believe so. I think the court would have entered default against the defendants. If my clients had ignored the court for over 300 days, I think we would be in a lot of trouble.
How do you get 300 days?
I believe it was 318 days from the time that Mr. Flippins it's located in my brief, and I apologize for not having the page in front of me. But there was a 300-day period of time where Mr. Flippins did not respond to any of the court orders. It's page 7 of my brief. Flippins effectively abandoned his lawsuit, having been given 318 days until the district court properly dismissed it with prejudice for failure to prosecute.
Anything further, Ms. Meltzer?
Yes, the standard for the district court's dismissal is an abuse of discretion standard, and that the district court, and that should only be overturned if the actions of the district court were considered fundamentally wrong. I believe that is the Johnson case. District courts have the inherent ability and the inherent authority to manage their own dockets. They should be allowed to control. They're the most familiar with their dockets, their caseloads, and the litigants before them. So I believe that this was not an abuse of discretion by the district court to dismiss Mr. Flippins' case under Rule 41B for both the failure to prosecute and the failure to respond to the motion for summary judgment, because there were 2 reasons why Mr. Flippins' case was dismissed. It wasn't just the failure to respond to the show cause, but it was the failure to respond to the motion for summary judgment. Mr. Flippins did have 4 explicit warnings prior even to the February 7th change of address filing of what would happen to his case if he failed to keep the district court aware of his address and failed to respond to a motion for summary judgment. He received all of those warnings well before the whole issue or the whole question of whether the district court had his correct address, which of course it is our position that the district court was under no burden to investigate his whereabouts. The district court very reasonably believed he was at the Huron Street address in Chicago when they sent his mail to him. There was a question during appellant's presentation regarding prejudice, and it would further be my position that yes, my clients would be prejudiced if this case were sent back. I believe the argument was that the defendants hold all of the evidence. I would respectfully submit that Mr. Flippins is a considerable piece of evidence because this is a medical malpractice. I should say it is an Eighth Amendment deliberate indifference case involving medical care, involving deliberate indifference in medical care, and Mr. Flippins is the one who is requesting the medical care. Mr. Flippins is the one that would be requesting compensatory damages. Mr. Flippins would be the one who asserts that he would be requesting punitive damages for the failure to provide him medical care. So how he is doing medically is very much a part of the evidence. And Mr. Flippins now, I would strike that. I would say that my clients would be considerably prejudiced if this case were sent back because so much time has elapsed since this case was filed in May of 2019. Witnesses' memories fade, evidence can be lost, witnesses can be hard to locate or unable to be located, so there would be prejudice suffered by my clients.
Do we know if the doctors involved here are still employed?
I believe the two physicians and the nurse practitioner are still employed, although I do believe one of the physicians is currently in the country of India.
Thank you.
A final point that I would like to make is that in the appellant's presentation there was discussion of, again, whether Mr. Flippins was entitled to receive an explicit warning, although I do say that he did receive 4 explicit warnings prior to the district court's dismissal of the case. The explicit warning standard was softened in the Fisher v. Singular Wireless case and the ISHEF Schaefer case. Even pro se litigants are not entitled to an explicit warning of their dismissal, and their pro se status does not, I would argue, does not come into the equation. If there are no further questions from the panel,
Thank you very much, Ms. Belser.
thank you very much.
Mr. Hasek, I'll recognize you for rebuttal.
Thank you, Your Honor. We addressed a lot of the points that were made in our reply brief, but I would just like to make a few points with my remaining time. Regarding the question of personal responsibility, Mr. Flippins prosecuted his case. He diligently submitted change of address forms 3 times, and the 300-day calculation is from August 2019, or I'm sorry, from May 29,
September
29th, thank you, Your Honor,
September.
through August, so it's basically the pendency of the lawsuit. But in February, that's when Mr. Flippins submitted the letter on page 5 that we discussed. So under any calculation of delay, it would not be fair to count that period because he's not receiving anything from the court after that point. And clearly his action to respond to the court's orders about the importance of updating his address shows his engagement in the case. Regarding the comment about 4 other warnings that were given, I think that is misunderstanding the standard. So what the law of the Seventh Circuit requires is that a warning be given before a case is dismissed under Rule 41 for failure to prosecute. So what the defendants are pointing to as the 4 warnings are, the first is the initial order where the court set expectations for Mr. Flippins and instructed him about the importance of updating his address. The second is the initial finding of merit for his claim to proceed. So those were not Rule 41 documents. And the third and the last one is the actual summary judgment that was filed by the state defendants. But the warning must come from the court. It can't be given by a party. And so I think it's important to stick to the law under Johnson and some of the other cases we cited that are specific about what the warning should contain. Regarding the standard review question, in our brief we addressed In the alternative, we do brief it under the abuse of discretion standard, and we rely on the cases of Bell and Stroga. Now, those are cases where this court overturned dismissals due to uncertainty about whether the plaintiffs had received notice prior to dismissal. In our case, we have objective proof that Mr. Flippins did not receive notice at his preferred address. And I asked the court to take a look at the document on page 5, because he expressly uses the term "my more permanent mailing address." And I think the use of the word mailing makes it clear. Mr. Flippins was pro se, and he was proceeding in form of pauperis, and it would be unfair to pro se defendants to impose strict obligations to monitor the docket using computer technology and things that not all pro se plaintiffs would have access to. Mr. Flippins in this case was clearly relying on mail service. He never consented to electronic service, and therefore the clerical error caused the dismissal. Mr. Flippins relied on the mail system to receive notice about his case. Thank you, Your Honor.
Thank you, Mr. Hasek. Thank you, Ms. Belzer. The case will be taken under advisement. That will close our hearings for today.